And welcome, everyone. Justice is a Process is here, and we have a very important show for you today. And it is dealing with what the state of Florida doesn't or didn't want you to see, didn't want the jury to see, didn't want anyone to see, and what they kept out of the trial. And there's a couple of important documents we're going to go through today that are absolutely going to, once you see them, once you understand them, it will give you a much better understanding of what's going on in this case. And this one of these documents, the state fought tooth and nail to keep out, and you're going to understand why when we get done with it. And we're going to get into all of that here tonight. We're going to go through. It's not going to be a lot of videotape. This is going to be a document-based deal here. So we're going to be reading through some things. So um, just be ready for that. Read along with me. I'm going to have them up and we're going to be reading them together, discussing them together. But when we get done with this discussion, you're going to understand why the people that are supporting Tyrone Tucker, once you read this information, you understand why, hands down, that this is a corrupt, problematic group of police officers that were involved in the investigation in this case, and that the investigation and the evidence against Tyrone Tucker is absolutely non-existent, and that there truly is an innocent man sitting down here in Florida right now fighting for his life, and tomorrow he'll be putting his life in the hands of 12 jurors. So we need all eyes down there one more day at least. Hopefully this thing comes back on the side of justice here, because the justice process, it's absolutely been subverted in this case. And right now, the fact that we can have a trial, we can put all this out there, we can have people watching, we can bring to light all these things, that is wonderful. But we got to make sure, hopefully, that the right result comes, because the right result in this case is not guilty, and you're going to understand why here in a little bit. So there's two key documents we're going to go over. And then there's going to be exhibits surrounding the one document that's going to be taking primarily amount of our time. And then the other document will stand on its own ground. So the first document that we're going to be discussing, let's jump into it here, is the suppression motion that the state fought tooth and nail to keep out of the case. And they did this for a reason, because they didn't want this in, and it's the Travis Johnson motion to suppress. And this document is absolutely on its own. We're not going to read the entire document because we don't need the entire motion, because some of the motion deals with Miranda issues and things that are not pertinent to Tyrone Tucker. But we're going to read the parts that are pertinent, and that is the facts here. So let me explain and give you some background on this document. You may have heard yesterday, on that would be Monday of this week, Mr. Tucker was trying to call a attorney by the name of Seth LeVay to the stand. And the reason for this is because Seth LeVay is John Travis Johnson's attorney. Now, the reason why this is important is the state was fighting tooth and nail out, and they played around. I believe they did. I think they played on Mr. Tucker's lack of knowledge, and the fact that they understand. It's not even lack of knowledge. It's just the fact that he's a one-man show. So it's impossible to get all these things done. Mr. LeVay understands how these things work and knows you need a valid subpoena in order to come to court. So what happens is, last week, there's delays. The state doesn't have witnesses for one day, and the subpoena for Mr. LeVay only ran through Friday. So what happens? On Monday, of course, the judge is specific. It says, have your people here. Well, Mr. LeVay doesn't show up. And Mr. LeVay contacts Mr. Tucker and says, I didn't show up because your subpoena ran out. Of course, then the judge jumps in on him and says, Mr. Tucker, you were supposed to have these witnesses here, and no excuses. And of course, Mr. Tucker has legitimate excuses, just like the state had a legitimate excuse, regardless of how the judge played it last week. And that was, or at least in the judge's eyes, they miscalculated the length of Detective Malone's cross-examination, so they had no witnesses. Here, Mr. Tucker had a situation where this was a legitimate thing that was a legitimate concern, because Mr. Tucker didn't have the ability to have witnesses come because they didn't show up because the subpoenas ran out. And that was due to the delays of the state. And of course, Mr. Tucker didn't know this because he's in trial all day on Friday, and he doesn't find out till Monday when the witnesses don't show. So as a result, he gets left without witnesses. The judge comes down hard on him. And then the judge, but what they really wanted to do was keep this motion to suppress out. And ultimately they did, because what they did is they filed, is the state immediately filed a motion to say to throw this out, and said, and then they used the fact that Mr. LeVay was not there. The judge threw out that there would be potential hearsay problems with this and attorney-client privilege problems, and as a result, they said, "Go on, we're throwing it out. You're not going to be able to use it." And the magic of having to have of why this motion was key is because of the fact that whenever a motion is filed in court, it's filed on behalf of the client. And now, attorney-client privilege is not attaching to something that's filed on record in the clerk's office. It would be what led up to that, or things that are not included in the motion, or things of that nature. But the motion itself and what's held out on that motion, it is not going to be subject to attorney-client privilege. It was filed in court. Now, here's the thing. Mr. Seth LeVay, as a member of the Florida Bar, holds that he has to hold out that he would never file a motion in court that he knowingly thinks is false. And that's important. So it can be inferred, even though this isn't a sworn statement, and this is what Mr. Tucker was going to be arguing, this is what he was going to try to get in, it can be inferred that by the filing of this motion, that Mr. LeVay would say that he would file this motion based on information he obtained from his client, which he had a reason to believe was correct and true. In other words, he can't file a motion that he thinks is false. So the section here under the entitlement of facts, which he includes in here, he can't file that with the court unless he believes those facts are true. Mr. Tucker was going to bring him in, go over that in front of the jury, and then enter the motion as an exhibit and allow that to go in as impeachment towards John Travis Johnson. Because the facts that are laid out in this motion directly contradict what John Travis Johnson testified to last week. One of the big ones is he looked Tyrone Tucker dead in the eye from the witness stand and said, "I believe Penny Phelps was a good investigator, and it wasn't that she was feeding me my story. It was that she was telling me a story, and because of what a wonderful investigator she was, she actually guessed the entire story right, and all I had to do was just say, yep, that's it." And she just happened to be such an amazing investigator that she literally, without any evidence at all, was able to figure this out. And that Penny Phelps is some superstar investigator. Obviously, she's lost her job. There's civil suits. A civil judge found that she was not credible, and that she wasn't a good investigator. And here in his own motion, he himself agreed that she wasn't either, and that the story that he told that day on that tape, brought to him by after 6 minutes of uninterrupted conversation from Penny Phelps, brought us to this to that statement. It was only after that he then turned around and told Penny Phelps exactly what she just told him 6 minutes earlier, and that was that Ty Tucker was the other guy. He was the driver, which that's not true. If anyone is involved in this, obviously it's Rory. We know that because witnesses at the scene put him there, and we also know a video exists of Travis Johnson's truck. Thereby, we can then ascertain that Travis Tucker or Travis Johnson was the other person. But in this, he clearly states, and that attorney clearly states that that statement was false. Direct contribution or direct contradiction, and essentially the nail in the coffin for the state's case. That's why they fought so hard to keep this out, because once you put a filed court document in where he says that the story he just told the jury is false, essentially that he committed perjury. So it's done. I mean, this jury would have no choice but to absolutely 100% acquit, because as was established today in the judgment of acquittal, in fact, the judge might even have had to grant that judgment of acquittal if this got in there. The judge knew that's what was at stake. That's why the judge threw this out. That's why the judge today, who based his entire reason for denying the judgment of acquittal today at the higher standard after the case was completed, on the fact that you could possibly believe John Travis Johnson, and that's only because this document didn't make it into court. So without further ado, having brought all that in, let's read this document, because this is explosive, and this is absolutely mind-blowing when you read it, when you consider John Travis Johnson's testimony, if you were watching last week. So here it goes. Comes now the defendant, John Travis Johnson, pursuant to the Florida Rule of Criminal Procedure 3.190 H1 through 4, by and through the undersigned attorney, and files this motion to suppress statements in the above styled matter, and in support thereof shows the following facts. 1. On November 22nd, 2017, John Travis Johnson was taken into custody at the direction of former Captain Penny Phelps by Detective Kevin Pitcher and Detective, and I guess that would be Malone, in the instant case under a pre-planned ruse in which Detective Pitcher misled Mr. Johnson into. It should be noted that during his initial contact with Mr. Johnson, Detective Pitcher first tricked John Travis Johnson into allowing the detective to search his truck, and thereafter, Detective Pitcher tricked Mr. Johnson into presenting to the Monroe County Sheriff's Office. So essentially, the whole premise, what he's saying here, the whole premise of why he came down, he was tricked to come down. He wasn't told he was coming down to discuss the treehouse incident. He was told he was coming down to discuss a theft involving his truck. From the outset, John Travis Johnson was misled by Detective Pitcher as to the reason and purpose of his interview. Towards that end, Detective Pitcher not only deceived Mr. Johnson into allowing a warrantless search of his automobile, but he also deceived Mr. Johnson into making a statement. So they got into Travis Johnson's vehicle to search it, thinking it was at the scene based on the videos they saw, and they did this backdooring the need to get a search warrant, because they really had nothing to get a search warrant with, backdooring it by suggesting to him that they were coming down to investigate a theft complaint that he put in. So he has no idea he's being investigated for the treehouse incident. Paramount to note, John Travis Johnson was the victim in an unrelated grand theft and criminal mischief case in which tools and other items were stolen from Mr. Johnson's truck. The perpetrators also keyed his truck, causing damage. 5. Along these lines, Detective Pitcher purposely lied to Mr. Johnson to trick him into going to the Monroe County Sheriff's Office to give a formal statement in connection with the grand theft criminal mischief case in which Mr. Johnson was a victim, and to identify and retrieve the tools and his other personal belongings relating to that case. So they told him he's coming down. They needed to finally get this statement because he had filed a report that he was coming down to give this statement and retrieve tools. And that was a lie. And they lied to him to get him down there. So after they lie to him to get him down there, they go one step further. Some of this you might say, okay, well, police are allowed to lie. They're allowed to do these things. But, again, this is just going to show you the ethics. What they do next is not allowed. Because once you're detained, once you're down, once you're being questioned, they got to give you something called your Miranda rights. And again, I'm only bringing this part of it. It's not that it applies to Ty Tucker, but it applies to the character of the detectives involved in this case, in investigating this case. So it's very important to consider that. After being transported from Pine Key to the MCSO interrogation room in Key West, Detective Pitcher continued the charade through which he persuaded Mr. Johnson into giving a statement. After talking for more than 30 minutes about this unrelated matter in which Mr. Johnson was a victim, Detective Pitcher requested that Mr. Johnson execute a written inventory release form for the property being returned to him in that unrelated case. Mr. Johnson complied. So he gets him down there and he says, okay, we're going to execute a written inventory release form. In other words, a form to get his property released. So in conjunction now with this form, number 7 says, in conjunction with having Mr. Johnson execute this written inventory release form, Detective Pitcher presents Thomas Travis Johnson with a written Miranda warning form and asks him to execute this Miranda waiver without ever informing or explaining to Mr. Johnson specifically what he was being asked to waive his Miranda rights for. So what he does is he says, we're investigating this grand theft of your car. When you want your your documents back. You need to sign this form. And also, because we're investigating this, we need you to sign away your Miranda rights too. So, of course, now that's illegal. You can't do that. He's got to know the case he's waiving his Miranda on. But they just needed to make sure that when they got him to say what they wanted him to say, and they broke him down and they used techniques that are known to create false confessions, that once they got down here, if they got something out of them, they needed to know they had that Miranda form so they could then present it and say, oh, here it is. To put it simply, in order to get Mr. Johnson to agree to talk to law enforcement without an attorney present, Detective Pitcher purposely failed to inform Mr. Johnson he was a suspect in a unaliving investigation, or that he wished to interrogate Mr. Johnson in relation to that unaliving investigation, prior to tricking Mr. Johnson into waiving his right to have an attorney present during the interview. Against this backdrop, John Travis Johnson never knowingly nor intelligently waived his Miranda rights at the time Detective Pitcher gets him to waive his Miranda rights. Mr. Johnson lacks a full awareness of both the nature of the right being abandoned and the consequences of the decision to abandon it. All right. Again, I'm not bringing this up because it proves anything for Ty. It's just to give you background, okay? To understand the guys, the people we're dealing with here. At the time, all right. So, anyways, we're going to skip number 9. That doesn't necessarily comport to anything. This is just discusses whether or not he's in custody or not. But all right, so we're going to skip to 11. Further, still, as soon as Detective Pitcher tricked Mr. Johnson into waiving his Miranda rights. Okay, so this is important. That there's 2 videos on Free Travis or no Free Franklin Tucker, and I presented the one that's after all of this. But essentially, this one you can see it's like you've got Pitcher in the room, and all of a sudden, boom. Penny Phelps just zooms in and then for 6 straight minutes just hits him up with her train of thought on what's going on and starts telling him, we got a problem. We got this. We got that. And I mean, it's incredible. But anyways, here it is. Further, still, as soon as Detective Pitcher tricked Mr. Johnson into waiving his Miranda rights, former Captain Penny Phelps entered the interrogation room and hijacked the interview with John Travis Johnson. In doing so, former Captain Phelps not only lied to Mr. Johnson about video surveillance evidence, which does not exist, but also the former captain repeatedly lied to Mr. Johnson regarding statements made by witnesses as well as other suspects, which were never made, in order to incentivize John Travis Johnson into making a false confession. All right. So this is where he's saying that Penny Phelps lied lied to him and made statements that weren't true about people and things that didn't exist. Okay. And he's saying this, right? And he's saying it resulted, well, let's finish it out. 12. Towards this end, former Captain Penny Phelps utilized what is known as the Reed technique of interrogation in order to incentivize John Travis Johnson to make, and here it is, a false confession. Because of its propensity to generate false confessions, the Reed technique is no longer accepted as an investigative technique by law enforcement, and because of its inherent unreliability, due process requires that any such confessions generated by use of the Reed technique be suppressed at trial. So what you just heard here in this motion is that the very way that the information, that the confession, that this statement was generated, the first time it's ever stated is through the Reed technique, which the method, the reason why they believe it leaves false confession because it makes the individual ripe for implanting memories into their heads, right? Which he did. And the problem is what she implanted in his head is that he was a driver of a truck. Ty Tucker was what was the other dude in the video, a video that later on is proven to not even have Travis Johnson in, but that Ty Tucker's the second guy. He's the white guy that's being stated that there was a white guy at the scene, and that Rory Wilson is, of course, Detroit. He's the guy that's there cutting necks, and that story originates by use of the Reed technique by Captain Phelps, a technique that is known and proven to create false confessions. It is that very confession, verbatim, that lands in court 6 years later with inconsistencies and issues, but it's what the state is now relying upon with no other corroborating evidence, no DNA, no eyewitnesses, nothing but this statement right here. This alone, we could stop this presentation right now. This alone should make you sick. The fact that the state of Florida knows this, knows what's going on. They're aware that this was filed. The prosecution's aware of this was filed because this is what prompted them to give John Travis Tucker a plea deal. And you're going to see why John Travis Tucker had to take that plea deal. Because we're going to get to the end. We're going to finish reading the entire facts, and then that's going to be the end of this document. 13, paramount to note, Detective Pitcher testified in his deposition that he disagreed with former Captain Phelps' interrogation techniques used to obtain John Travis Johnson's confession because her techniques increased the possibility of obtaining a false confession. Straight from the lead detective there. 14, tantamount to note, at the outset of interrogation in the instant case, John Travis Johnson asked Detective Pitcher if he needed to have an attorney present during his interview. At this juncture, instead of terminating the interview or affording Mr. Johnson the opportunity to speak with an attorney, Detective Pitcher dissuaded Mr. Johnson from having an attorney present and continue with the interview. 15, now this is important. I'm reading this because you need to understand what you saw on the witness stand. Why he did this. As part of this motion, he states the following: John Travis Johnson hereby reserves the right to supplement and amend this motion to suppress. Among other things, this defendant was recently declared insolvent for cost, and defense counsel is currently seeking JAC approval for the retention of an expert witness in law enforcement interrogation techniques and the Reid technique. Now, what we're going to say here is he was recently declared insolvent. It means he has no money. It means he's trying to get approval by the court for an expert that he believes is absolutely imperative for him to win this motion. But most importantly, it tells you he doesn't have money. He doesn't have the ability to hire an attorney. He doesn't have it. So knowing this, he's broke. He's sitting in jail. The state comes to him and says, listen, if you drop this motion, we'll drop your case. You plead guilty. We let you out, but you got to show up in court. And then we're going to put a clause in there that says if you show up at court and and suddenly have a sense of morality and say, I can't do this against Mr. Tucker, well, you're going to jail for life because you've already pled guilty and you've already given us a recitation of facts that we can take you back to court, and with a judge's ruling, no trial, you're going to prison for the rest of your life. That's what was hanging over this gentleman's head when you heard him testify. And of course, Mr. Tucker did a great job of bringing that out. But that's also why, if this would have been allowed to come in, he gets annihilated. Because in this, prior to taking that deal, he's telling the court that the statement he gave was false and not true. And Seth LeVay is allowed to come to court and say, yes, when I filed that, I had every belief that it was true. And that came from my client, nowhere else. And he can say that on that very thing. He can't get into the specifics of conversations or details, but he can say that you can infer based on the fact that I filed that I had a basis to believe it was true, because otherwise I wouldn't have filed it and I'd be in trouble with the bar. And that's very important. That's very, very important. Now, the next document, give me a moment here. We're going to get this queued up here. So then the next document will be a motion to dismiss. And it's let's see here, motion to dismiss. Let's see here. Yes. All right. So motion to dismiss is what we're going to do. Let's pull it up right here. And we're going to go through this. Now, we're going to take little field trips while we're reading it. Okay. It's 17 pages long. We're going to read it in its entirety. This is where, okay, if your blood's already boiling right now with the idea that the state puts a witness on that they know is lying, they cut a deal with this guy instead of dismiss the charges, you're going to hear all about why and what they did here and the absolute dastardly dirty details of what's going on in this case. And it is scary that this is allowed to happen in this country. Let's jump into it. All right. So here we are. defendant Franklin Tyrone Tucker's motion to dismiss indictment and information. So we're going to start reading this, and like I said, we'll jump off a little bit here and there and start going through some things here. Defendant Franklin Tyrone Tucker, hereinafter referred to as Tucker by and through undersigned counsel, hereby files this motion to dismiss the indictment and information and moves this honorable court to dismiss the indictment and the information in the above styled cause. And as grounds and in support thereof, alleges the state is aware the prosecutor presented perjured material testimony without informing the court, opposing counsel, and the grand jury, thereby violating the defendant's due process under the Florida Constitutional, Article 1, Section 9. The undisputed facts upon which this motion is based on are as follows. Now, what you can assume here, again, Mr. Tucker filed this with attorneys. Attorneys had to review this. They had to have a belief that the information that they're about to share in this motion is true. So we can infer that there is truth here, or at least that there has been an investigation that is strong enough that his attorneys, his two attorneys that were handling his case at the time, had a firm belief that what's being presented in this motion is true. And we're going to show you some of the backed up exhibits and documents that came along with this that further back that up. But let's understand what we're dealing with here. What they're alleging is that Colleen Dunn, the ASA, and you're going to hear in this that Dunn, Phelps, and Malone, who we all got to know in this trial, are all friends. They're all a group of people that are operating together. There's sordid relationships involved here with those three individuals. They're very close. So what happened? What ended up? What Tucker got ensnared in here unknowingly, as he got ensnared with a group of people, powerful people, in powerful positions who could help each other, who could help cover up each other's mistakes, and who could help each other never, ever have to admit they made a mistake. And when one gets going or one decides they're going after somebody, the whole crew does. Now, there's a lot of things that happen in this case that, again, this is stuff the jury is unaware of completely, that we're going to be presenting to you here today. That's going to shock you, and that we're just going to leave them as questions, because I don't know. We don't know. We can't understand why this. All we can tell you is they happened, and it raises grave questions about everything that was going on here. But anyways, the idea here is that Colleen Dunn presented testimony, perjured testimony she knew wasn't true, to the grand jury, to the court, unopposed. She knew it. She didn't inform anyone, and she became aware of this. And as a result, if that happens, it's a due process issue. And what that means is basically a due process issue is in layman's terms, if you want to kind of salt it down, it's basically anything that would prevent you from being able to defend yourself. In other words, if you can't, if a law is vague, it's impossible to defend against. If someone's lying against you, it's impossible to defend against a lie. As a result, the only remedy when your due process rights are in fact violated is dismissal. Now, it doesn't mean it's complete dismissal. The judge has the ability to say it can be dismissed and it can be represented to a grand jury or represented elsewhere. But as they're going to explain in here, they believe certain levels, certain actions and behaviors are so grave and so terrible that you can get your charges dismissed and they can never file them again. In other words, they messed it up so bad, they've poisoned the process so bad, and they've poisoned the case so bad that it's no longer fit to ever be used against you, and therefore it's going to get dismissed. And that's what Tyrone Tucker was asking the court to do. And this is what he was referencing at the end of the state's case when he filed his motion for judgment of acquittal. And he filed it. And of course, he didn't fully, I think he understood what he was supposed to do, but he used the opportunity, as the judge said, to let off some steam. And his goal in this case, very clear, is to let people know about this. And he used that forum and that opportunity to put it out there, knowing there's cameras watching this case, knowing people are watching this case, to discuss these issues. And we're going to get into it. We're going to do one better for him. We're going to discuss and read and go over some exhibits from this, because if people see this and people are trying to be honest about this case, it's got to upset you and infuriate you. But anyways, with that said, in that introduction, let's jump in here and start reading. On December 19th, 2017, the state filed a one-count indictment against the defendant alleging first-degree felony murder. Former Assistant State Attorney Colleen Dunn, hereinafter Dunn, presented the case to the grand jury. The only witness called was Detective Matthew Pitcher, hereinafter Pitcher. So understand this, what we've just read. Matthew Pitcher was the only witness called at the grand jury. In other words, he is the only person that was relied upon by the grand jurors to indict Tyrone Tucker. And this is important because if Pitcher is not being honest, or if presenting dishonest information, or is given a script, right, of dishonest information, known dishonest information, and he presents that and an indictment is gotten, that's a due process violation. That's an issue because it's known false information that the grand jury relied upon that is material to the case. It's got to be material to the case. And absolutely the things you're going to hear that we're lied about are absolutely material to the case, omissions or lies. Anyways, the state charged that on November 17, 2017, in Monroe County, Florida, Franklin Tyrone Tucker, Rory Hank Wilson, and John Travis Johnson did unlawfully kill Matthew Reed Bonnet, a human being, while engaged in the perpetration of or in the attempt to perpetrate a robbery, contrary to Florida Statute 78204(1)(a)(2). And in the commission of said offense, Franklin Tyrone Tucker and Rory Hank Wilson did personally carry, display, use, threaten to use, or attempt to use a knife, a weapon, contrary to Florida Statute 775.0871. And in perpetration of said offenses, Franklin Tyrone Tucker and Rory Hank Wilson were wearing a hood, mask, or other device that concealed his identity, contrary to Florida Statute 775.0845, Exhibit A. The state also filed an amended information charging the defendant with robbery with a deadly weapon, aggravated assault with a deadly weapon while masked, battery while masked, aggravated battery, deadly weapon while masked, and tampering with a witness. Ms. Dunn was the only person who swore to the allegation contained in the amended information. So she swore to that information. Basically, they get him indicted on one count, and then she files an information with the court, which is basically where they take the fact that an officer of the court, again, comes in with the expectation that they will not lie to the court and that they will represent truth to the court. She comes in and says, this is all the facts I know, and I'm representing them to be the truth. The court takes her at her face value. Now, when informations are filed, it allows potentially preliminary hearing to be filed. It could still be potentially, I think, presented to the grand jury, at least in West Virginia, it can. But it, it does allow for additional hearings after an information is filed. But it allows the charges to be filed nonetheless. Forces their appearance in court, forces the bond to be set, forces court dates to get going, etc. Ms. Dunn was, well, I already read that. So the Florida Constitution provides that no person shall be deprived of life, liberty, or property without the due process of law. The state violates this section when it forces a person to stand trial and defend himself against charges that it knows are based on perjured material evidence. That's Anderson v. State. And that's basically a case that deals with this. It's where, I guess, an issue like this came up, and the court in that case found what you just heard. Government misconduct that violates the defendant's due process rights under the Constitution requires a dismissal of charges. Florida Regulating Bar 4-3-A states that a lawyer, okay, and this is important right here, shall not knowingly offer evidence that the lawyer knows to be false. This is the Seth LeVay thing. We were just talking about this. If a lawyer has offered material evidence and comes to know its falsity, the lawyer shall take reasonable remedial measures. So sometimes a lawyer, has information they think is true, but if they find out it's not true, they've got to go to the court and let them know, and they've got to take measures. Remedial measures simply means they got to take corrective measures. They've got to go correct the problem, and they've got to go let someone know so that they could start the process of correcting things that were based on the false information or the bad information. 7, a prosecutor who permits a defendant to be tried upon an indictment which prosecutor knows is based on perjured material testimony without informing the court, opposing counsel, and grand jury violates due process. That's Florida Constitution, Article 1, 9, USCA Constitution Amendments 5 and 14. So that's Florida Constitution 1 and 9 and United States Constitution, 5 and 4, Amendments 5 and 14. Eight. Not only did the state violate the due process rights of the defendant at the grand jury, but also during the course of the investigation and the prosecution of this case. 9. The record is replete with repeated instances of egregious misconduct by Colleen Dunn, former Captain Penny Phelps, hereinafter referred to as Phelps, and others. One of the others being Captain or Detective Malone. 10. Just one example of the state's acknowledgement of this fact is its agreement to suppress the statements of Naeem Jackson, a known paid informant who Dunn had placed into the cell of the defendant in total violation of his constitutional rights. 11. The state knows Dunn prepped Pitcher before he testified before the grand jury. The state knows Dunn went so far as to prepare a script of what she wanted Pitcher to say at the Arthur hearing to deny the defendant his right to pretrial release. So let's take our first field trip, everyone. And we're going to go and I'm going to show you this document. Let's go here. Or share this. And this is the first document here. This was prepared and sent to Penny Phelps, Matthew Pitcher, Barney Sadrick, and Daniel Malone. Subject matter treehouse case, June 25th, 2019. Can someone review the CVS recordings and see if there's anything of value? Roosevelt, let me make sure I got the. Oh, you know what? I apologize. This is not the right motion here or document here. Hold on a second. All right. I got to go into my file here. I pulled the wrong memo out of my file. I do apologize. Oops. Hold on here. It does happen from time to time. All right. Let me see here. Let's see here. Let's get the right one up here. I think this is it. Let me make sure. Nope, that's not it. Pulled up the wrong one again. I think it's this one right here. Here it is. Yes, I found it. All right. So I found it. Let me get this in. All right. And let's get this up here for everyone to see. All right. Exhibit M. So here it is. Kara Higgins, from Colleen Dunn to Matthew Pitcher and Penny Phelps. Hearing tomorrow. I'm sure more will be covered. It will all depend on how the questions go, but here's the bulk of what will need to be covered. See you guys at 12:30. And this is essentially what you're looking at here is essentially a script that she sent out in regards to what she wanted everyone to say. And it omits a lot of information. Discuss Todd O'Quinn's statements. Also add that he heard it was April behind it. Okay. Discuss that Anathea Clay is MIA. She wasn't. She was living right near the crime scene. And when it comes to Todd O'Quinn, interestingly enough, I believe, if I'm not mistaken, where does she say Todd O'Quinn says two people, one is white, leaves out the fact that, of course, he says clearly it's not Tucker ever. Says that multiple times. Can't pick Tucker out of a lineup. Says when he's receiving the lineup that he believes it looked and resembled the individual that he knew as Travis Johnson, but he wasn't 100% certain enough to say it was Travis Johnson, but he said it looked like Travis Johnson. And here it all is. This is what she provided Pitcher, and it's what Pitcher ends up testifying to. And a majority of it, as you're going to hear in this motion, is incorrect. It's false. It's incomplete. There are things that are some outwardly false, some are omitted, but she had an obligation, and Pitcher had an obligation to present to the court a honest recitation of the evidence, an honest recitation of what she knew these witnesses were being said, or at least Pitcher did. And by having transmitted this, she's essentially helping for Pitcher to commit perjury, helping Pitcher to put false statements on the record, and knowingly doing so, thereby violating Tyrone Tucker's due process rights. This is why Tyrone Tucker was so mad, because of course the judge didn't end up granting this motion. He isn't going to grant this motion. The only way this case ends is with these 12 jurors tomorrow getting this case and finding him not guilty. But anyways, I want to show you guys that. We're go back to the document here. Let's get back into the motion to dismiss. Is this? Make sure we get to the right one. All right. So the state knows Dunn prepped Pitcher before he testified before the grand jury. The state knows Dunn went so far as to prepare a script of what she wanted Pitcher to say at the Arthur hearing. We just saw that. To deny defendant his right to pretrial release. Detective Pitcher admitted that he omitted exculpatory witness statements in his testimony before the grand jury. Logic dictates that there is no conceivable way Pitcher would omit statements by Todd O'Quinn, a victim, after being asked what O'Quinn observed, unless he was directed by the prosecutor to state only part of what O'Quinn said, and not the exculpatory parts of his statements to the police. This is clearly evidence of a conspiracy to obstruct justice and to present perjured testimony to the grand jury by submitting selective testimony that perverts the true meaning and significance of O'Quinn's statements. And listen, O'Quinn, there's a reason why I put O'Quinn here first. The first video I ever did on this case, breaking it down, O'Quinn's there. And he's talking to Pitcher. And several statements of O'Quinn's have been used. But the first one I ever put up, he's sitting in a chair. He's at the treehouse. He's talking to Pitcher. The next day, he's talking to Pitcher. Mr. Pitcher knew what O'Quinn's testimony was. And it was very clear that it was not Ty Tucker, that he didn't know the person. He didn't recognize him. And when Ty Tucker becomes a suspect in subsequent statements, he continues to say, I can't believe it. It doesn't seem like it. It really doesn't seem like it's him. It doesn't say it just didn't look like him. It didn't look at all like him. And that was hidden from the grand jury. Not only was it hidden, they hid his statements. They didn't even bring him up when they took this to the grand jury. In the Arthur hearing, which is what we saw, I said that was a memo from for the grand jury. I was incorrect on that, but the memo we looked at was from the Arthur hearing. The Arthur hearing being a bail hearing that Ty Tucker was entitled to try to get him out of jail and have bail set. And they've got to make a showing of evidence and various things. And she gave him a script for that to go in, and they omitted certain details. They omitted the parts that proved beyond a reasonable doubt that that Ty Tucker's innocent. It proves it when you start hearing these statements. And it shows that he should never have been charged. 13. Defendant Tucker made his first motion to obtain the grand jury transcript in this case on June 11, 2020. Defendant asserted that he had been made aware that at least one detective, Pitcher, and the former prosecutor, Dunn, had lied to the court about this case. The state opposed the defendant's motion, and the court subsequently denied the motion. A motion for reconsideration and renewed motions continued to be made by the defendant over the next 3 years. It was not until the end of 2022 that new assistant state attorneys, who had not been subjected to working with Dunn, finally agreed to the release of the transcripts. The state knows Dunn, Phelps, and others committed misconduct in this case and now has an obligation to take remedial measures to protect the due process rights of the defendant. And that's as of the Florida State Bar 433. Dunn's egregious prosecutorial misconduct in her presentation to the grand jury requires the dismissal of both the indictments and the information at a very minimum. Now, whether or not they have a right to represent is another story, but absolutely. As the state is aware, Dunn was not only suspended by the Florida Bar once, but twice. In recent years, for her conduct in this case and in others. So her actions in this case, the actions specifically dealt with a confidential informant and what she did in that, and how she represented things to the judge or to the court. She got suspended. She's no longer able to practice law. As of the date of this filing, Dunn is not even eligible to practice law in Florida. To date, the state has continued to oppose the defendant's numerous requests to depose Colleen Dunn about her clear involvement in the investigation in this case. And wouldn't you think the state, who's not supposed to be about winning, they're supposed to be about finding the truth, getting justice for the individuals in here that were the victims, and they're supposed to be doing that fairly. They're not interested in the truth. They're hiding it. Why not let her get deposed? Why not let her answer questions? I mean, why are you hiding her? 16. State's witness, former Captain Phelps, was also terminated by the Monroe County Sheriff for her misconduct in this case. Phelps, the state witness, had the sheer audacity to file a civil lawsuit against the defendant merely for asserting his constitutional right to proclaim his innocence in this case. Phelps not only sued the defendant, but also his wife and undersigned counsel Higgins, alleging defamation and civil conspiracy for bringing Phelps' misconduct to the attention of the court and to the public. So Miss Phelps expected that no one should talk about it, that a man's on trial for his life, potentially going to go to jail for life, and that he shouldn't be allowed to put up a defense against her just because she's a captain of the police. That's the level of arrogance of these people, that they commit unbelievable misconduct. She feeds stories to two different suspects in this case that did this crime. She feeds them a story, a lifeline, offering them deals if they frame Tyrone Tucker. And she does it blatantly on camera. She stops the camera for 3 minutes. You're going to learn about all of this. And then she says, "Oh, you're daring to talk about this in court? You're daring to defend yourself? I'm going to sue you." Luckily, of course, you can file a lawsuit, but it doesn't mean it's going to go forward. And luckily, the courts dismissed it or gave a summary judgment. I have that. We're going to go on a little field trip on that in just a moment. For bringing Phelps' misconduct to the attention of the court and public. On March 31st, 2023, after 2 years of discovery and litigation, the Honorable Jose E. Martinez granted summary judgment in favor of the defendant, his wife, and his attorney, finding Phelps offered no evidence to prove defamation. This court finds, as a matter of law, that no jury could find by clear and convincing evidence the existence of actual malice in any of the statements at issue, Exhibit C. Defendant was forced to spend financial resources, time, and energy that could have and should have been used in his defense of his felony murder charge on a baseless defamation suit filed by the state's primary witness. So essentially, she goes after this man. She attacks him. She locks him up. She conspires to try to get him locked up with no bond. And then when he gets bond and he's fighting back and he's filing motions and he's uncovering the malfeasance and the corruption, she says, "I'm going to sue you and drain you financially." I mean, this is evil stuff. This is everything this guy. So when you look at Mr. Tucker in court and you say, that's an arrogant guy, that's not arrogance. That's not a jerk. That's a guy who is upset and rightfully upset. That's a guy who the state of Florida is trying to railroad into prison for the rest of his life. And yeah, is he going to treat those prosecutors with any deference or respect? Is he going to treat a judge who's ignored this and ignored this and ignored this and ignored this time and again and is aware of all of this and has deprived him of having counsel at the table, or at least a hybrid defense? In other words, where he was going to have someone in the courtroom at time, as a advisor. He deprives him of that and then starts complaining about the fact that the trial's not going smoothly, or and about Mr. Tucker's lack of information. Look, Mr. Tucker has been through hell and back, and that's what you're seeing the result of in that courtroom. Not arrogance, not disrespect. You're seeing a guy who's, in my opinion, showing incredible resolve. And what you're seeing in there, many more people would lose it. I've put up videos on this channel of guys who've lost it with the court. We had a guy the other day jump across the bench at the judge. Mr. Tucker's doing none of those things, although he will be warranted to do all of them, because what's been done to him is far worse than what was being done in any of the other cases I've ever put up where somebody attacks the court or does something. And I'm not suggesting that should happen, but I'm saying he has carried himself with the dignity and absolute control, self-control, more so than many people would show, given everything that he's going through. And you're going to see this. You're going to continue to see this as we look deeper into this. But I want to show you, give me a moment here. So this is the ominous. This is the order for summary judgment. We're not going to go through and read all of this, but I just wanted to show it. This is where a civil judge, and this is what there was. I'm showing this because the judge made references. This is a civil court. I don't care what a civil judge found. It makes no difference here. But it talks about things that were done. And the plaintiff, and this is one of the things where the Deputy Malone, uh, uh, essentially, Phelps was recorded stating this. This is what Phelps was recorded saying, directing Deputy Malone to do this. Just listen to what she's recording here. Just do this. Hang out, make a traffic stop. If you have to do a legitimate traffic stop, we'll have a road patrol deputy come over and meet you, and you can write a ticket with road patrol deputy. I just need somebody that can be in the area, Lee. This is Deputy Malone's husband, or not Deputy Malone. This is Detective Malone's husband. I guess he's Deputy Malone. But this is her husband, Detective Malone, who you saw on the stand. This is her husband that she's talking to. I just need someone that can be in the area, Lee, and not leave, because I don't know when he's going to move or if he's going to move, but I got to have a marked unit in the Bearded Dwarfs, and David Smith have been told to keep you in their sights in case the traffic stop goes badly, but to stay the hell away from the traffic stop, because we don't want Detroit knowing that, and that we know who the hell he is. We want it to look like you, the grumpy old man. You have nothing better to do. You know, you're the white supremacist. You're messing with the black guy riding the bike. She's telling and instructing a white deputy to act as if he's a white supremacist cop, right? That he's essentially profiling him, and that way he doesn't believe he's under any suspicion. That's her thought process. This is the lady that we have. Now, this is why she's ultimately let go. You know, I want you to be the neo-Nazi that's picking on the black guy. I mean, can you, like, unbelievable, unbelievable. So that, you know, she was upset because they talked about this, because this came out. So, you know, I'm just kind of scrolling through to show you the contents. It's a rather long, lengthy document. And essentially, this judge finds that there was nothing wrong committed, and finds that um, it finds in favor of Tucker and his wife and his attorney, and essentially finds that her behavior, again, what they were warranting their basis for it, because what she was saying was is that her misconduct, which one of the elements that you have to prove is that she would have to prove that she didn't do it, that they were falsely claiming. The judge didn't find that. The judge found that there wasn't evidence that it was false, that she did commit misconduct, and that there was no malice or maliciousness in the statements, that he was just defending himself. Anyways, I wanted to bring that out. I wanted to point out that statement because it's going to come back here as we continue reading. So let's get back into our document here. I believe this is it. I hope. Let's get this one right here. Yep. All right. Here we are. So, defendant was forced to spend financial resources, time, and energy that could have and should have been used in his defense of this felony murder charge on a baseless defamation suit filed by the state's primary witness. And she was supposed to be the primary witness in this case. And you didn't hear her testify in this trial because she ends up essentially getting fired from the police department for her actions and behavior. And then she, like I said, attempts to drain Mr. Tucker's financial resources, attempts to cost Mr. Tucker's wife a lot of money. Obviously, she was assisting Mr. Tucker with the cost of his defense. 17. The state is aware that defendant and his counsel were subjected to other harassments and threats of intimidation by Dunn and Phillips. The state is aware Phelps was told by Dunn to pack the courtroom during a status hearing, resulting in Phelps ordering dozens of her then subordinates to intimidate counsel and the defendant. The state is aware Dunn even interfered with the defendant's right to marry his wife. Okay, so what they're talking about here is basically they have emails proving that in an attempt to try, because they were upset that motions were being filed and his attorneys were advocating for him and wanting to bring out the things that you're going to hear that were being done here, that she was trying to get a jailhouse and snitch, to lie and say that she heard a confession. She was trying to do all these different things. She'd obviously done what she did with Travis Johnson, and all these things are coming out, and she's getting mad. So what she does is she says, we need to get the whole force in here. We need a show of force. Bring in all these undercover agents, all these cops, and let them know they're on my side. Essentially, it's you three, it's you two attorneys and Mr. Tucker versus us, and you want to take us on? You attorneys want to take us on? We all have eyes on this courtroom. We're all watching, and we're all going to do something. Intimidation just textbook intimidation. She did that. It's terrible. Anyways, on top of that, they interfered. There's evidence that they were interfering and knowingly and intentionally getting in the way and causing issues, because Mr. Tucker at one point wanted to marry his now wife while he was in jail. And she got in the way of that and filed motions to do that, and made comments in emails where she says, basically, hey, I'm doing this on purpose. We're not going to let him get married. Just showing such bad faith. Again, where does this come from? We don't know, because what you're going to hear in this case, once we get into the real crux of this, when we get into the picture deposition, it's going to blow your mind. Anyways, the state is aware through the deposition of Phelps that Phelps and Dunn are still in communication, and that Dunn assisted Phelps in her now defunct civil lawsuit against the defendant, his wife, and his attorney. The state is aware suspended attorney Dunn and terminated former police officer Phelps conspired and continued to conspire to wrongfully prosecute this defendant in their vile vendetta. The state knows Dunn and Phelps acted illegally, and it knows that no defendant should ever be forced to stand trial and defend against false allegations made by corrupt law enforcement officers. It is time for the state to right the wrongs of Phelps and Dunn. Detective Pitcher has told the state what it needs to know. After the suspension termination of Dunn and Phelps, Pitcher was deposed. Exhibit D. His testimony regarding the investigation of this case and interference by Dunn and Phelps is nothing short of alarming. What is abundantly clear is that Pitcher was now willing to detail the misconduct he observed and participated in, because he knew he was finally free from retaliation by Dunn and Phelps. And we're going to jump to, and I've got it up on another screen you all can't see, so I'll continue to read. I'm going to read to you what we're looking at, and then we're going to read the page and find the information that's contained that's relevant. There's several relevant pieces here regarding that are going to blow your mind once we get through this, and adds context and light to what you've already heard in the case. Probably answers some questions about some things, or maybe it even creates some more questions. But this is where it's really disturbing, and as the attorney said, alarming. So let's pull this up. Give me a moment. All right. So first page. Like I said, I'm reading this off screen. You guys are seeing the deposition. So the first page here, I'm going to bring up the first section here. It's always going to be one page ahead. All right. So based on the testimony of Detective Matthew Pitcher at his deposition held on March 8th, 2021 and March 10th, 2021, the following was disclosed. Phelps was on scene before Pitcher was on scene on the night of the crime. Remember, Pitcher is the lead detective here. So here it is. Let's look at this. This is page 77. Let's read his testimony. Question. So who was in charge when you got there? Sergeant Kellenberger or Phelps? Answer. I believe it was Kellenberger when I got there. Question. Was Phelps there too when you got there? Answer. Yes. Question. Did you see her talk to Colleen Dunn? Answer. I don't recall. Question. Are you aware? And again, you were in Major Crimes November 17, 2017 when the crime occurred. That is correct. Question. Are you aware of any narcotics operations that were happening in or around the treehouse on the night of the murder? Answer. No. Did Juan Lara have a job going on in that area that night? Answer. Not that I know of. Question. Was there a cop car parked in the CVS parking lot at the time of the murder? Answer. Yes, I believe so. Whose car was that? Answer. I believe, I could be wrong, I believe it was Jenna Moeller. Question, what was she doing at CVS parking lot? We're just going to go a little bit deeper into this. Answer, I don't recall. You would have to ask her. Question, but you think she was there? Answer, I think so. I could be wrong, but I thought I remember that. Question, was she handling any sort of narcotics operation that night? Answer, not that I'm aware of. Not that I was told. No. Question, did you ever ask her? Answer, no, I did not. Question, did you ever say, hey, what are you doing hanging out in CVS parking lot? Answer, no. Question, so you just didn't find that strange? Answer, I mean, I don't know if she was just wanted to get a drink or what the situation was. I never thought about it. Question, you didn't ask her? Answer, no. Question, the CVS video, did you look at the video that night from CVS parking lot? Answer, no. Did you have a question? Did you have any role whatsoever in obtaining the CVS video? Answer, no. Question, have you ever seen video from CVS? Answer, no, not that I recall, but I could be wrong. Anyways, that ends the relevant portions there. Next relevant portion is Phelps was more involved in this investigation than any other captain he had previously. Okay, so first thing we're going to take from this first section, Phelps, done. We got the captain of the police, a state attorney are already on scene before the lead detective gets there. Why are they there? And again, you might say, well, that might be typical. Well, we're going to take care of that here on page 85. Let's go to page 85. Question, you do not know who was in charge, you or Phelps? I think I asked you that, and I think you said it was you. Who was in charge? Answer, I was the case agent, but she is still the captain, so I take direction from her. Understand what he's saying here. He's the agent in charge, but when the captain comes on, she's the captain. She's running it. But why is a captain at the scene? And let's see what he has to say about that. Are captains normally as involved as Penny Phelps was in this case? Answer, she was more involved in cases than any other captain I had previously. Question, you know why? A, no, I do not. Question, so she was more involved in this particular case, this specific case? Answer, yes. And that's important because there it is. Earlier he says in cases, but in this particular case, her involvement went above and beyond her normal. Okay. Then then you would expect the captain. Answer, from my previous experience, yes. Question, so you didn't talk to Anathea Clay at all before she was allowed to leave? Answer, no. Question, do you know whether she talked to Captain Phelps before she was allowed to leave? Answer, I do not. Question, you also spoke to Benjamin Hansen that night, and he lived downstairs on the property, right? Now, this is Ben Hansen. I played him in a previous video, so we'll see what he says here on this. Yes. Question, and did he tell you that the first suspect came out of the gate and kept running, and that the second was a large black male with a knife who came down the stairs and attacked Todd O'Quinn? Answer, yes. Question, was Hansen the first person to tell you this guy's name was Detroit? Answer, I can't remember the order in which I spoke to people because obviously Paula also said it was Detroit. Question, and then after talking to Ben Hansen, that is when you talked to Todd O'Quinn, right? Answer, yes. Question, and you remember Mr. O'Quinn telling you that this first suspect that he saw run was a white male with average height and brown hair, approximately 140 to 150 pounds. Answer, that sounds about correct. The only thing he said was he didn't get a good look at him because he was wearing a mask. He didn't see his face. Question, do you remember him also describing the other suspect as a large black male with a knife? Yes. Answer, yes. Question, you noticed blood on Mr. O'Quinn's t-shirt when you interviewed him that night at the scene. Why didn't you collect the t-shirt? Answer, I don't know. Question, do you know if anyone ever collected that shirt? Answer, I do not. So, question, so after you interviewed Todd O'Quinn, then you went to Tom Thumb, right? Answer, yes. Question, and that is when you talked to Michael Alexander. Answer, correct. Question, okay. Now there was no Tom Thumb surveillance video that you collected at that time, was there? Answer, no. Question, okay. Answer, the only thing I don't know there is in one of the interviews, and I'd forgotten this until my investigation, on my video, which I believe is a text, is a picture of the Tom Thumb video. Question, do you have that picture? Answer, no, I lost it when my phone reset. Question, when your phone reset? Answer, yes. It would have been February or March. My work phone completely reset itself. I took it to IT. They recovered what they could, but basically everything was lost. If that doesn't sound like a suspect story of them trying to cover stuff up, I don't know what does. Question, well, that was when? In 2018? Answer, yes. Question, okay, so you had the picture from 2017, right? Answer, yes. So they have a picture of the suspect that you heard Michael Alexander talking about, who puts um, a bloody sweatshirt in a trash can. Although I suspect that was, well, I don't know. Maybe I think Alexander would have known it, Quinn, but yes. Question, why wasn't it turned into evidence immediately? Answer, it should have been. I did not. Question, do you remember what the picture was? Answer, I do not. So he doesn't remember what the picture was. He knows it was on the phone. It was significant enough that he remembers it was on his phone. So he has to know it was something there. Anyways, so they were never able to get the surveillance from the Tom Thumb store. But anyways, that's all the relevant information from that section. So the next section that we're going to go to is section 102. And this is where Phelps told Pitcher to keep physical evidence from this case in his office, contrary to departmental rules. Okay, so she's telling him to keep evidence out of the evidence locker, violating chain of custody, eventually voiding the ability to use that evidence or know that evidence, where it's been, what it is, and where and that it's usable. Anyways, all right, so let's read this. How did that happen? Obviously, answer. Obviously, that is why the complaint was sustained and it was a mess up. Question, whose mess up? Answer, mine. Question, did Penny Phelps tell you it was okay to keep physical evidence from this case in your office? Answer, for longer than normal period of time, yes. It's still my responsibility. I should have done it sooner. Question, Penny Phelps is the captain, right? Answer, yes. Question, did you find evidence in your office that someone had placed there without your knowledge? Answer, yes. Question, what? Answer, it was the victim's clothes from the Lower Keys Hospital. Question, when you sent evidence to the lab to be tested, did you send it all at one time? Answer, if I remember correctly, I believe it was 5 times. Question, I show you a copy of the letter? Answer, is it okay if I use the bat? Okay. So anyways, so there you have it. Next relevant piece of information is on page 104. All right. And this deals with Phelps and Colleen Dunn played equal roles in the investigation of this case. So let's check out this. Answer, by receiving lab reports back with an unknown, and I believe it was actually Colleen Dunn who caught it that we didn't have hers. Question, so Colleen directed you to go get the swabs? A. Answer, yes. Question, who played a bigger role in the investigation of this case? Penny Phelps or Colleen Dunn? Answer, you would have to ask them. Question, no, I'm asking you as the lead detective. Answer, I would say it was about equal. Question, about equal. All right, can you play the video? Okay, so this is in regards to getting the buccal swabs that were supposed to have been gotten and were never gotten, I believe, from Paula, but I could be wrong on that, but I'm pretty certain that's who it was. So here you have it. Yep, the ASA and the captain have equal responsibility that supersedes the lead detective here in this case. Unbelievable. And the question is, why? Again, as we get into deeper into this stuff and things that were done, why was that necessary? All right. So here we go. Next phase. Phelps, the former detective, now demoted to dispatcher, Danielle Malone, relied on a Facebook picture of Tucker in his Halloween costume as reason to charge him with murder. Page 146. Answer, that is correct. Question. So you have now Danielle Malone and Penny Phelps are close, right? Answer, that is correct. Question, have you heard rumors that they were sexually involved? Ms. Poyce, I object to relevance. Now, again, they're going to take the question on because when you're doing a deposition, judge rules on it later. But anyways, we got to hear the answer. Question, have you heard that rumor? Answer, no, I can't. I have heard rumors, but you hear rumors about everybody. Question, but did you hear that rumor that they were physically involved? Answer, yes, there was a rumor. Question, okay. And they are friends, right? Answer, yes. Question, they are friends inside, outside of work, right? Answer, yes. Question, so Danielle Malone and Penny Phelps make a big to-do over this Facebook post, don't they? Answer, I can't recall if it was a big to-do, but definitely they were excited about it. Question, they were excited because he wore a costume on Halloween, right? Answer, yes. Question, okay, so based on that information, they determined that he is a suspect, right? Answer, I believe that played into it, yes. Question, played into what? You didn't have anything else? Answer, correct. I want that to set in with you guys. Played into what? You didn't have anything else? Correct, meaning they didn't have anything else linking Tyrone Tucker to this case but that picture. Question, are you okay with that? Are you okay with them developing him as a suspect because of a picture on a Facebook page from Halloween? Answer, I wouldn't say suspect, a person of interest because of the fact that he had also been walking with Rory the next day. Question, but it wasn't the next day. Answer, you're right, correct. Question, days later, right? Answer, correct. So they come back from their break for lunch. Question. Okay, all right. Detective Pitcher, before we took a break, we were talking about Penny Phelps and Danielle Malone using the picture of Ty Tucker that they pulled from his Facebook page when he was wearing a Halloween costume, where you then had reason to claim he was a suspect. Answer, yes. Question. You're a detective. Is it difficult doing your investigation when you have a captain there that is also doing her own investigation? Answer, yes, it can be difficult. Question. Was Penny Phelps a bully? And this actually goes in. That's why I continued reading on this, because this goes into Phelps being described as a bully. There's another section that says Phelps does not feel, Pitcher does not feel Phelps acted properly in this investigation. We're going to get into all of that here on these next 2 pages. She is very persistent to make sure she gets her way. Question, and she's your superior, right? Answer, yes. Question, so let's say you wanted to go in a different direction. Would you have felt free to do that with her being there? Answer, I could give my opinion of what might be good, but the ultimate decision comes down to her. This is understanding that when she inserts herself in this position as a captain, as a ranking superior to the lead detective, she gets to take over the investigation. So that's why she was able to run into that interview room with Pitcher sitting there and take over that interrogation and start interjecting herself. It's also, of course, going to be Pitcher's going to say, this is why I didn't stand up to her. But still, as a police officer, he has an obligation to stand up to anyone that's trying to put an innocent man behind bars. And he should have. But anyways, neither here nor there. So, even though she is a captain and you're the lead detective, answer, right. Question, are you attempting to protect Penny Phelps? Answer, no. Question, how about Colleen Dunn? Answer, no. Question, do you think Penny Phelps acted properly throughout this investigation? Answer, no. Obviously, she was released for one thing. Question, and that is directly insubordinate to act like a neo-Nazi white supremacist. That's the comment that she made. I wanted to bring context to that because I knew it was coming up. You heard the entirety of that comment. Answer, correct. Yes. Question, and you heard her make those statements. Answer, yes. Question, IA asked you about it, right? Answer, yes. Question, and you said that you had never heard her act like that before. Answer, right. Yes. Question, and she made those statements to Lee Malone, right? Answer, I believe so, yes. Question, Danielle Malone's husband, that's Detective Danielle Malone, who we just heard. She's now a 911 operator. But that's who we've heard testify multiple times in this case this past week and last week. Danielle Malone's husband? Answer, yes. Question, so in this conversation that you're having on the 20th, and again the 18th is when you go back to the crime scene. The 19th, you didn't do anything. The 20th, you receive information that Ty Tucker walked to Metro PCS with Rory Wilson and paid Ty Tucker's cell phone bill. Answer, correct. This is 3 days. I want you guys to understand this. Everyone asking, how did Ty Tucker get involved? 3 days after, there's no evidence. There's not a person that's brought Ty Tucker's name up. 3 days later, he walks into Metro PCS with Rory. And you're going to hear now what happens. There's a informant that tipped off Pitcher that Detroit was down at Metro PCS. And let's pick up right from there. Answer, correct. Question, and you have Malone and Phelps all excited about this Facebook picture from Halloween, right? Answer, correct. Question, did Captain Phelps in these conversations that you're having at headquarters on the 20th, and these are recorded in a empty interrogation room where they inadvertently left a recorder on, these conversations are being had. That's the only reason why they are able to question him about this. It's the only reason why he's talking about them. And of course, he's going to be as vague and memoryless as possible, except for areas where he's on recording. Do you remember her saying that Franklin Tucker is the white guy? Answer, I can't remember verbatim, but yes. And that's what he's questioning about here. Question, and again, you had no evidence, right? Answer, correct. Question, nothing. Answer, correct. Question, did you ever say, why do you think that? Answer, no, I did not. Question, so he was guilty by association? Answer, he was. He became a person of interest or suspect because of the association. Question, but Penny Phelps is telling you that is the guy. That is the white guy. The brain trust of Penny Phelps and Danielle Malone are telling you that is the white guy, right? Answer, correct. Some comment like that was made. Right. Question, and you don't think to say why? Answer, I don't recall asking why. No. Question, so you never. So I am missing something here. Answer, I don't recall. Question, did you ever speak with William Peoples? Yes, I did. Answer, yes, I did. Question, and did William Peoples ever identify Tyrone Tucker as a suspect? And William Peoples is his CI, I believe. Answer, no, he did not. Question, he did not? He gave you information about Detroit, right? Answer, yes. Question, but he never said anything about Ty Tucker being involved in this. Answer, no, he did not. Question, do you remember Captain Phelps saying that day we need to think about what we're going to go after Franklin with? Answer, again, not verbatim, but something along those lines. Question, and at that point, she had proof that he paid his cell phone and walked with Rory. Answer, correct. Question, do you remember saying in response, the only thing that worries me with Franklin is he the one that actually killed him? Answer, yeah, I think I remember that. Question, because you weren't convinced that this white guy, whoever that white guy was, that played a role in this. You weren't convinced that this white guy did the stabbing, were you? Answer, correct. Question, why not? Answer, at that time, we didn't have anything to point to that. Question, nothing. Tim, would you bring up the 911 call, please? So you did have a 911 call. Did you ever listen to it? Now, this is a 911 call that Gabby, I'm going to get into this because I played this tape. So I want you to understand this. We're just going to roll right on up to number 60 because number 60 or page 60, when we get there, that's the next thing of or area of substance here that they point out. And it says, Phelps said, I hope Todd can ID him, meaning Tucker. Otherwise, Jesus Christ, we're all in trouble. So this will give us good context leading up to that statement, which is a very disturbing statement because why are they in trouble? We don't know. Again, one of the many questions circulating around this thing. Anyways, let's get back into it. Yeah. Answer, yes. Question, from the night of the crime? Answer, yes. Question, okay. And there was a girl by the name of Gabby, a student at FKCC, right? Answer, yes. Question, and she was talking to 911 and made some observations, right? Answer, yes. Question, and she is also simultaneously talking to 911 and talking to Todd Quinn. Answer, right. Question, okay. And now there's a video playing. Question, can you pause it, Tim? Okay. So the 911 call that you did have at the time said some dude just killed two guys. Answer, correct. Question, right? Answer, yes. Question, there was no indication from Todd O'Quinn at that point anyway that there were two people, right? Answer, correct, from that phone call. Question, that did the stabbing. Answer, correct. Question, okay. Question, Todd O'Quinn is running around the parking lot telling people to be careful because he is coming up, right? Not they, he. Answer, yes. Question, okay. And they're playing videos here. Some of the videos have been aired. I believe all of these videos have been aired in subsequent videos. I'm not playing them right now because we're trying to keep the spirit of the deposition. I told you this is going to be documentation tonight. Question, okay. She is seeing this real time. This is Gabby he's talking about. She's seeing the vehicle, right? Answer, right. Question, so a vehicle, not a truck, right? Answer, correct. Now, we dealt with this, and I've given you my opinion on this, that I believe the coloring being the same is significant. And given the fact that an eyewitness retains about only 30 to 40% of the events, it's very easy for mistakes to be made. It's why people can see short and tall guys and everything else. Perceptions are all different. So she could have perceived that vehicle in a split second moment that she responds to and says, I think it was a sedan and it was a truck. It Those mistakes can be made. What we also have to do is bolster that with whatever cameras are around. And we know a camera is around. We also know if, again, I'm not saying John Travis Johnson is correct in anything that he says, but in his own statement, he says he doesn't leave until he's Tyrone Tucker or whoever that, is running out. Now, I believe, again, most of what John Travis Johnson's doing in his statement is he's moving things around and changing them but they're his own actions that he then changes to fit Tyrone Tucker being the driver. So in that case, I believe what he's saying is yeah, my truck was there. I run out, I get in the car, and I get the hell out of there and leave Rory Wilson behind. But this lady says she saw Rory Wilson, or what would have been Rory Wilson, at least according to what this deposition says, get into a dark colored sedan, which would mean then that, of course, and again, this is very possible, that everything that John Travis Johnson is just simply telling a lie, and that Rory did get in, and that Travis went out, Rory comes out, they jump in the car, and again, as you're going to see here, it heads back in the direction of the warehouse. So, anyways, okay, so she's seeing this real time. She's seeing the vehicle, right? Answer, right. Question, so a vehicle, not a truck, right? Answer, correct. Question, and that the guy is getting into it, right? Answer, I think it was a guy. Question, she said the guy. Answer, no, that's fine, the guy. Question, okay, continue playing. Question, so getting into a black sedan, pulling out real fast, going back to the direction of the warehouse, correct? Black sedan, not a truck, right? Answer, right. Question, where did the truck come into play? Answer, I don't remember the truck coming into play until the Cosme video. Question, but you knew about this the night of the crime, right? Answer, yes. Question, what efforts did you utilize to locate the sedan? Answer, I know there was a bolo put out for it. Question, okay. Answer, outside of that, I don't know. Question, did you ever see if Anthea Clay had a black sedan? Answer, no. Question, did you ever see if her live-in boyfriend had a black sedan? Answer, no. Question, did you ever investigate any of these other people that were at the treehouse that night to see if they had a black sedan? Answer, no. Question, or access to a black sedan? Answer, no. Question, but this witness is watching this happen, right? Answer, yes. Question, do you remember saying that the 911 call is really the best evidence as far as this investigation? Do you remember saying that? Answer, vaguely, not verbatim. Question, okay. So we have a black sedan, a bolo put out for it that night. Any results? Answer, no. Question, on the 18th, anybody look for a black sedan? Answer, not that I'm aware of. Question, on the 19th, you didn't do anything. Answer, right. Question, and on the 20th, you were looking at Facebook pages. Are we looking for a black sedan? Answer, not that I'm aware of. Question, all right, continue. They're playing a video now. Question, black guy with a mask killed two people and now he is running, right? And again, what they're playing, I believe the video is, I think it's of the 911 call or of her statement to the police. Answer, correct. Question, so no mention of a white guy? Answer, no. Question, no. But yet you're convinced, or Penny Phelps is convinced, that the white guy did the killing. When did that theory develop? Answer, that I am not positive. You would have to ask her. Question, what about for you? Answer, the question, Todd O'Quinn said he saw somebody running, right? A white guy run, right? Answer, yes. Question, brown curly hair, mask. A lot of people were at the treehouse that night, right? Answer, right. Question, we went through a list of all the people that left the scene before you even got there, right? Answer, yes. Question, Belinda Corrales, Roosevelt Washington, Roger Rugat, Todd O'Quinn, and Michael Alexander. Roger Rugat is white, correct? Answer, yes. Question, Michael Alexander is white, right? Answer, yes. Question, do you know if there were any other people there? Answer, not that I know of. Question, do you know that Belinda Corrales testified at her deposition and she said there were tons of people there that night? Answer, I think I vaguely recall that. Question, you talked to Belinda Corrales, right? Answer, yes. Question, and somehow her video got lost as well, right? Answer, I believe that was one of the ones that was malfunctioning. Question, so we can recover that? Answer, that is correct. Question, okay, continue. Question, so then there is a statement that the black guy killed the white dude, right? Answer, yes. Question, Todd O'Quinn talked to you the night of the crime, right? Answer, yes. Question, and then the next day he changed his story, right? Answer, yes. Question, what did he tell you on the 18th? Answer, I had him walk through the whole thing with me on the 18th. If I remember correctly, let me make sure I don't get it wrong, that he and Matthew were together in the trailer. They heard the screams. Matthew went upstairs to check to make sure everybody was okay. Todd started heading towards CVS, came back. When he started back is when he saw the person run away that took off the mask because they were running away. And then he went toward the stairs is when he met the other subject. And the other subject made a comment. I don't exactly remember what he said. And then he said there was a wound on his pinky. At that time, he was in the middle. He was in the middle section, and then the subject kept going. Question. So who is the one that was supposedly who cut his pinky? The white male or the black suspect? Answer, the black suspect. Question, did you take a swab from Todd O'Quinn? Answer, I did not. Question, so Todd O'Quinn said the knife was involved. You noticed some blood on a t-shirt that he was wearing the night of the incident, but nothing pertaining to Todd O'Quinn was ever sent to the lab. Answer, no. Question, why not? Answer, I did not send it to the lab. Question, Todd O'Quinn's version of the events has changed a few times, right? Answer, correct. Question, has his description of the white suspect ever changed? Answer, it has not. Question, has he ever wavered on Ty Tucker being involved? Answer, he has not. Question, he has maintained consistently that he was not involved, right? Answer, that is correct. Question, and he has also never changed the description of the white suspect. Question, that is correct. This is corroboration of Todd O'Quinn by picture. This witness who the state kept from getting into the trial. Again, another aspect. You put Travis Johnson's motion in and completely decimate his testimony. You put Todd O'Quinn in, who says it was a curly brown hair, clearly says it was not Tyrone Tucker. And again, you see what Mansfield was doing today, trying to go after him for Paula to say, oh, he's discrediting. He's trying to influence. Todd O'Quinn, he's never tried to influence. Todd O'Quinn's been consistent from day one, just like Paula has. Only difference is they're trying to take advantage of Paula. It's despicable because she's the victim in the case. She's the victim, a surviving victim in this case. And those prosecutors are re-victimizing her by making her have to live with the fact that a man she knows didn't do this may sit in prison for a crime against her. It's despicable. Question. So when you were talking with Penny Phelps on the 20th and you're discussing possible suspects and what happened, do you remember talking about Todd O'Quinn's second interview? Answer, I don't remember any specifics, but I remember I know we talked about it then. Question, do you remember saying he saw Matthew get stabbed in the chest like this several times, but we know that is not true? The fight may have gone on from there, but he doesn't know it. And the white boy who took off his mask may have fled, and now he is still fighting, but now he's got the big guy to deal with, and the big guy finishes him off, stabs him in the back, and that is the problem with Todd's story. Do you remember saying that? Answer, vaguely. Question, do you remember Captain Phelps saying, I'm wondering if skinny guy doesn't go down the stairs first, kept going, and Detroit comes down the stairs and stabs Matt in the back? I vaguely recall it. Question, okay, so that was a possibility at the time, right? Answer, yes. Question, that Detroit came down the stairs and stabbed Matthew Bonnet in the back, right? Answer, that was talked about at that time. Question, do you recall responding to her? Yeah. Do you recall responding to her? Yeah, that is what I was worried about. We think it's over when white man leaves, and that's not the case. Answer, I vaguely remember saying something like that. Question, do you remember discussing that there must be two separate knives because some witnesses reported a straight blade and some reported it being serrated? Answer, yes. Question, do you remember Captain Phelps saying it could have been skinny guy punching Matt and Matt trying to hold on to him, and he comes down, stabs Matt in the back 3 times to get Matt off Franklin? Also, explains why Franklin takes off his mask if he already punched Roger 3 times. Now, he punched Matt. I hope Todd can ID him. Otherwise, Jesus Christ, we are all in trouble. Now, this is set on tape. This is why we know it was set. Answer, that was what Penny Phelps was saying, correct. Question, yes, do you remember that? Answer, vaguely, yes. Answer, question, why would you all be in trouble? Answer, you would have to ask her. Question, because she's already come up with an entire theory of the case without any evidence whatsoever to justify that as far as Franklin Tucker goes. Answer, you have to ask her. Question, she says to you as her captain, we are trying to, figure out what happened here. She says to you as your captain, Jesus Christ, we're all in trouble if Todd can't ID this guy. That doesn't concern you? Answer, it means we have more work to do. Question, more statements to take, right? Answer, correct. Question, Todd never ID'd him. Answer, no, he did not. Question, so maybe Jesus Christ, we're all in trouble. What do you think she meant by that? Do you know? Answer, I don't know. You'd have to ask her. Question, well, when you heard it, how did it make you feel? Ms. Poist, objection relevance. Answer, I don't recall how that made me feel. Question, what was your reaction? Answer, I don't recall what my reaction was at the time. Question, the captain is telling you that if we can't get Todd to identify Franklin Tucker, we're all in trouble, and he hasn't identified Tucker, right? Answer, correct. Question, were you fearful that there would be trouble? Answer, I was not at this time. I was not. There was not even enough to. This was the 20th, I believe, correct? Yes. At that time, we didn't even have Tucker under arrest. And you see what he's going to say. There wasn't even enough to have Tucker. And he realizes there wasn't even enough when they arrested Tucker. At this time, all you have is that he paid his phone bill. A, answer, correct. Question, do you remember Captain Phelps saying, so the smooth knife was the skinny guy? The doc will be able to tell us if it was a serrated edge or a skinny edge, and that tells us who did the stabbing. And then the other one we can go, and you can go to prison for murder too. Answer, I remember. Question, do you remember responding exactly? It doesn't matter to me. Now we're going to move on to 166. So let's go down here, which will be 167 on this. We're just going to go ahead and skip ahead to this. So question, the suspect's car, and what this is, just you guys don't have it in front of you. So the relevance of this to this report that we have is Phelps decided the getaway car was a truck and not the black sedan described in real time by the 911 caller. So they discuss this in a little more depth. Question, so the suspect's car is a black sedan, right? Yes. Answer, yes. Question, and so Penny Phelps decided it was a truck, right? Answer, correct. Question, isn't there a problem with the Cosme video timestamp? Answer, I believe it's off. Yes. Question, you acknowledge that, right? Answer, yes. Question, timestamp is off? Answer, yes. Question, and you have already testified that you can't see anybody in those pictures. Answer, that is correct. You can't make anybody out. Question, even though you used it at the Arthur hearing to keep my client in jail for another year, you can't make anybody out, correct? Answer, correct. Question, and you knew the suspect's car was a black sedan. Answer, if you listen to the 911 tape, and from what I remember, part of what you hear them talking about, even in a 911 call, the subject running at that time, and that was after she brought up the black sedan. Question, where is the truck? Answer, the truck was already gone at that point. Question, so you're basing this information on a video that you can't make out where the timestamp is messed up. Part of the videos are missing, right? Answer, the truck component, you can make out a truck in the video. Question, but Gabby, she is our best person? Answer, at that time, yes. Question, at that time, she's not our best person anymore because she doesn't say what Penny Phelps' theory of the case is. Answer, once the video, you can see in the video, it is a truck. Question, but the timestamp is messed up, right? Answer, yes. Question, and there's pieces of the video missing, right? Why is the video in two sections? Answer, I don't have an answer to that. However, it was downloaded. Question, and who downloaded it? Answer, it would have been the people at Cosme. Question, are you sure? Answer, you would have to ask Danielle Malone. Question, Danielle Malone again. Dispatch Dan Malone, right? That answer, that is correct. So instead of relying on what you heard on that 911 call, you want to rely on a video with an incorrect timestamp where you can't make out anybody and that is chopped up in pieces. Answer, I wouldn't say it's in pieces. Question, it's in two pieces, isn't it? Answer, correct. Yes. Question, that is more reliable than a 911 caller who is telling you what is happening in real time? Answer, I wouldn't say it's more, but I'd say it's equal at that point. Question, equal? Answer, correct. Question, were there other witnesses that were identified that have possible information about the crime? Yes, I believe so. All right. So, um, a couple things to add there that gave context to. Number one, you may have heard Mr. Tucker talking about there was a witness he was going to call. This witness was in charge of the videos, and he was going to bring to light the fact that several exhibits, several videos were chopped up, and that the Cosme video in particular, the timestamps are all on it. It's chopped up into individual pieces. And that's part of the reason I noticed that the timestamps are all jacked up, because you literally see the truck arrive and it looks like 8, 7, 8, 9 minutes elapses. So, there's a possibility. I mean, because we know, listen, because we don't know, and maybe we do know, I don't know, but I haven't seen any evidence yet that definitively says that was, in fact, Travis Johnson there, right? So I think there's a strong possibility that maybe that truck arrived and has nothing to do with the crime. That the two people that leave that truck, get out, walk, may have nothing to do with the crime itself at that moment. And then the individuals you see running 6, 7, 8, 9 minutes could be completely unrelated, or some of it could be related, but that the events, the truck pulls up, guys get out. For all we know, they could be unrelated. It could be the timing could be completely off. And that's the scary part in this case. We have an eyewitness who says a black sedan pulled up. And again, I've explained why I think she could be mistaking that for the truck. But just take it at face value. The police have not pursued it. The police have not ruled it out. The police have done nothing to further to either confirm or say, hey, that's not related. Instead, what they do is they go on Facebook. And what a valid, powerful point that is to be made. And that's why it's a shame that this guy didn't get on the witness stand, because if this guy gets on the witness stand and these things are brought out to the jury, there's no way a jury would come back with a guilty verdict. Anyways, let's proceed here. We're going to go to page 178, which will be 179 on here. And the relevant portion we're looking for in this instance is that Pitcher did not feel there was enough evidence to arrest Tucker. Phelps made the decision to arrest him. So let's read this. Question. Actually, here we go. We're going to answer. Answer, yes. I shouldn't say put him in custody, but to grab him and to try to interview him. Question, try to interview him? Answer, yes. Question, okay. Was it you that decided to take Ty into custody? Answer, no. Question, whose decision was that? Answer, that would have been Captain Phelps. Question, Captain Phelps, so the search warrant is executed. You know that Mr. Tucker told you that he feared he was going to get shot, right? Answer, yes. Question, and you know that he was handcuffed, right? Answer, yes. Question, and you know that he was taken down to the station? Answer, correct. Question, and he was asked questions? Answer, yes. And he was placed in the back of a patrol car. He was handcuffed, right? Answer, I believe. I don't think I actually got to see him in the car. Question, and at this point, he paid his own cell phone bill and walked with Rory Wilson? Answer, yes. Now, before we go in, as we get on here, I want to go over what we're going to see here as we go over the next few pages, because basically between this page and, for all practical purposes, all the way up to 198, or we'll just say probably 200, I'm going to read to you what we're looking for, because there's going to be a lot of things going on that we're going to read here. And we're going to go over it. So after 178, we got 179 to 180. Pitcher believes Phelps told alleged victim April Phelps what to say. We've got Pitcher found Phelps' conduct during the investigation concerning. That's going to be 182. We've got Pitcher watched Phelps tell Rory Wilson what to say and led him down a path, insisting Rory Wilson implicate Tucker, pages 187 to 188. And at 1:18 a.m., the morning of Rory's statement, Rory says, if I say Ty did it, I can go home. And then suddenly the recording stops. 3 minutes of the recording are missing, page 187 to 190. Next, once the 3 minutes elapse, recording suddenly continues, and Rory tells Phelps the story of how Tucker helped to plan the robbery, 187 to 190. Pitcher was concerned that Phelps fed Roy the story he should tell, page 190. And Phelps was coaching April Walker the second time Phelps met with her, page 195. And Pitcher believes Phelps manufactured evidence in this case, 198. And then we'll skip ahead to these next two, which there's two more. Actually, there's a few more points. Sorry. That we've got going on here. Like I said, this is the largest part here, but this is very important. What you're going to be reading now as we go down this rabbit hole of this testimony, it's going to blow your mind. Anyways, let's get to work. Question: what was your probable cause to detain him at that point? Answer: at that time, I was dealing with Rory Wilson. You would have to talk to Captain Phelps. Question: was anybody other than Rory Wilson and Ty Tucker detained for questioning that night? Answer: no, I don't believe so. The people were spoken to at the warehouse. Question: why wasn't April Walker taken as a suspect? Answer: she was not considered a suspect at that time. Question: you did have surveillance showing that she was destroying evidence, possibly, right? Answer: yes, there was a video of her with the bag. Question: did you watch the video of Captain Phelps and April Walker? Answer: I did, yes. Some of it was a while ago, but I did watch it. Question: because Captain Phelps took it upon herself to pull April Walker off to the side and talk with her, right? Answer: yes. Question: and based on your observations of the video, did it appear that Captain Phelps was asking questions or telling April Walker what to say? Answer: you would have to ask her. I would be speculating. Question: I'm asking you, based on your observations, watching the video of Captain Phelps confronting April Walker, was Captain Phelps asking her questions or was Captain Phelps telling her what to say? In my opinion, telling her what to say. Question: telling her what to say? Did you tell Judge Jones that at the Arthur hearing? Answer: no. Question: no. And to be clear, at this point, there's no evidence, right? There's nothing against Ty Tucker. Correct. Question: so now they have Penny Phelps, according to your testimony, telling April Walker what to say. Does that alarm you? Answer: you'd have to ask her. Question: I'm asking for your opinion if you are alarmed by that as the lead detective in this case. Are you personally alarmed by that behavior? Answer: yes, it's very concerning. Question: did you find it strange that April Walker now comes up with a story that Franklin Tucker is in the warehouse changing his clothes 4 hours after the murder occurred? Answer: I wouldn't say I found it strange. Question: Penny Phelps told her to say it, right? Answer: I would assume Penny Phelps told her that she needed to be honest if she wanted to help. Question: you would assume you watched the video. You already said Penny Phelps told her what to say. That was Penny Phelps' story, not April Walker's, right? Answer: it would be April Walker's story. Question: once she gets it from Penny Phelps, it makes it her own, right? Answer: when she realizes she has to be honest, I believe. Question: when she realizes she has to be honest, or when she realizes she has to parrot back what Penny Phelps tells her to say? Answer: you have to address that with her. Question: that was your observations, correct, detective? Answer: my observation was the video was concerning. Question: okay. Any forensics done in this room where he is supposed to be changing out of these bloody clothes? Answer: no. Question: no any forensics done in the warehouse at all? Answer: no. Question: well, did Captain Phelps then take this a step further and tell you that April Walker called her and told her that Ty threatened her? Answer: yes. Question: did you have any proof of that? Answer: no. Question: did you do any sort of investigation? Answer: I did not. No. Question: so you already admitted that when you saw Captain Phelps, that what you saw Captain Phelps do was concerning, and yet you continued to allow her to make these statements and accusations without so much as an investigation by you? Answer: correct. Question: why? Answer: I trusted her. She was doing the right thing and that the statements were true and accurate. Question: but you already saw her do this to April Walker, right? Answer: right. I don't. Question: did anybody else hear Ty Tucker threaten April Walker? Answer: no. Question: no. And there was no investigation done with regard to that, right? Answer: correct. Question: and this is all Penny Phelps talking to April Walker on a telephone, right? Answer: correct. Question: so there's no recording of any of this, right? Everything is after the fact. Answer: correct. Question: when you did arrest Ty Tucker, you told him it was for witness tampering, right? Answer: yes, I believe so. Question, was he thoroughly confused about what you were talking about? Answer, if I recall correctly, yes. Question, all right, because he believed that you were upset with him talking to Paula Bellamont at McDonald's, right? Answer, yes, I believe that is correct. Question, and you say no, that is the conversation you had with April Walker. And he said, I never had a conversation with April Walker, right? Answer, I believe that is correct. Yes. Question, did Penny Phelps and Danielle Malone interview a witness named Austin Odom in September of 2019? Answer, yes. Question, nearly 2 years after the incident. Answer, yes. Question, why 2 years later? Do you know? Answer, no. Question, as the lead detective, you don't know? Answer, I do not. Question, Danielle Malone recorded it on her own body cam, right? Answer, yes. Question, where is the video? Answer, I do not know. Question, what happened to it? Answer, you would have to ask her. Question, you have no idea why it was never turned over? Answer, no. Question, did you ever see it? Answer, no. Question, never watched the video? Answer, no. Question, were you concerned that Danielle Malone were going out and interviewing witnesses 2 years after the crime allegedly occurred and an oops, lost the video? Answer, I was concerned we'd lost the video. Another lost video. Question, they did write a supplemental report, right? Answer, yes. Question, and Austin Odom talked to April Walker the day that April Walker was allegedly threatened and her unborn baby was allegedly threatened by Ty Tucker, right? Answer, yes. And Austin Odom said the only thing she was concerned about is a place to stay and money, right? Answer, yes. Question, because she can't stay in the warehouse anymore, right? Answer, no. Question, the search warrant was executed and the landlord is kicking everybody out, right? Answer, that is correct, yes. Question, she wanted a place to stay and some money. He didn't say anything about her indicating that she was threatened, right? Answer, no. Question, and didn't say anything about her appearing scared and frightened, right? Answer, not that I recall. No. Question, watching Penny Phelps. Penny Phelps is adamant that Franklin Tyrone Tucker, will kill April Walker and her unborn baby based on what he allegedly said to her, right? Answer, yes. Question, that only Penny Phelps and April Walker heard, right? Answer, correct. Question, well, only allegedly April Walker. Penny Phelps didn't hear anything, right? Answer, are you talking about the threat itself? Question, yes. Answer, yes. Question, she just told April Walker what to say, right? Answer, you have to address that with her. Question, do you believe she told April Walker what to say? Answer, I believe she coached her some, but it was still April Walker's state of mind. Question, when you talked to Rory Wilson, he said April didn't see. Ty changed his clothes in the warehouse at midnight, right? Answer, correct. Question, he was adamant about that, right? That is correct. That is correct. And you said, well, why would she make that up? And what did he say? Answer, because she hates Ty. Question, because she hates Ty? Answer, can we take one more break? Sure. All right. So let's see here. I believe, yeah, we're gonna go into. Okay, so we're right at the Rory Wilson situation here. Actually, and I apologize. I have hoped that this was Travis Johnson's motion to suppress. It's actually not correct. This is Franklin Tucker's motion to suppress, but we are in, I believe, nope, yeah, Detective Matthew Pitcher um, deposition here. So let's just put that up here. And let's get back to reading here. All right. Okay, back on the record. When you brought Rory Wilson in for questioning, you began his interview, right? Answer, that is correct. Yes. Question, okay. And what was it? Well over an hour, right? Or at least an hour and a half you were talking to him? Correct. Sorry. Yeah, right around there. And he was adamant that he walked with Travis that night, right? Answer, correct. Question, and he wasn't with Ty, correct? Isn't that what he told you? Answer, correct. And he also said, we just talked about that April hates Ty. So of course she's going to say that he was changing clothes and that he didn't believe that, right? Answer, that is correct. So what you're hearing here is Rory Wilson says Ty wasn't involved. And we know Rory Wilson was involved. But he is saying Ty's not involved, at least originally. He's like, what are you talking about? He says April's lying. There's a problem between April and Ty. Anyways, so let's get back here. So, answer, that is correct. Yes. Question, okay. So then Captain Phelps comes into the room around 20 minutes to 1 in the morning, right? Answer, yes. Question, okay. Prior to Captain Phelps coming into the room, did Rory Wilson make any incriminating statements about Ty Tucker? Answer, no. Question, no. So Captain Phelps comes in and she tells him what to say, doesn't she? Answer, she gives him a path to go down. Right. Question, she says, now this is what happened, quote. Now this is what happened, right? Answer, yes. Question, right? Answer, yes. Question, and she tells him what to say, right? Answer, yes. Question, and Rory, for a little bit, continues to deny that April ever said that, right? Answer, correct. Question, Phelps tells him, we know you were with Tyrone that night, and Rory adamantly says, no, I was with Travis, right? Answer, that is correct. Question, but Captain Phelps repeatedly tells Rory that she knows he didn't kill anybody, but that Ty did right. Answer, that is correct. Question, now it's 1 in the morning, right? Answer, yes. Question, he has been there how long? A couple of hours? Search warrant? Answer, yes. Question, and then at 1:18 in the morning, he says, if I say Ty did it, can I go home? If I say Ty did it, can I go home, right? Answer, yes, he said that. Question, the video ends. Tell me if you agree with me or not, or we'll play it. The video cuts off and there's 3 minutes missing, right? Answer, correct. Question, the video immediately stops after he says, if I say Ty done it, I can go home. Video stopped. Who stopped the video? So what he's talking about here is during the interrogation of Rory Wilson, finally, after hours being in the interrogation room, after having been outside standing handcuffed, brought in there, waiting. He just wants to go home. He's tired. He's got a pregnant wife. And he says, so you're saying, and he's been adamantly denying that Ty has had any involvement. He's claiming he doesn't. And finally, after Phelps is bringing Ty up and making it clear that she wants to hear something about Ty, he finally breaks down and says, listen, so you're saying all I got to do is say Ty did it? And then the video cuts off. 3 minutes pass. We don't know what happens during those 3 minutes. Now, well, you're going to hear some of what it is, but you're going to hear later in this deposition that Rory Wilson later testifies what happened and that Phelps threatened his wife, threatened if he didn't come clean, or at least told him that his wife was under threat. I'm not sure. I haven't seen the transcript, but some threat was made or impending threat was going to happen with his wife if he didn't come forward and say what she needed. And he agrees to say Ty did this. And then she tells him she's going to protect him. Of course, she didn't get a deal, but she gets the incriminating statements against Ty, which she's hoping Rory will testify to. And then, for whatever reason that she has that she wants to bring Ty down, she's able to go out and get him and arrest him. Anyways, let's pick up where we're leaving off here. Question. The video immediately stops after he says, if I say Ty done it, I can go home. Video stopped. Who stopped the video? Answer. I do not know. Nobody should have stopped it. I believe it was a mechanical error. Question. A mechanical error? What happened in those 3 minutes? Answer. I do not recall. Question. You were there. Answer. Yes. Question. Was it more than Phillips telling Rory what to say? Answer. She would have. I can't say for sure she was saying this is what happened. I can't say for sure she was saying this is what happened. Question. And we have the quote from her like that is what she said. She said this is what happened. Answer, absolutely, yes. Question, so in that 3 minutes, where there's conveniently no video, did she continue with telling Rory what he is supposed to say to go home? Answer, I don't remember what he said. She would have continued saying along the same lines as, you are not the bad guy. As you are not the bad guy. Question, you got to tell me, Ty. Ty did it, right? Answer, right. Question, so after the video returns 3 minutes later, does Rory tell you a story about Ty helped to plan the robbery? Answer, yes. Question, okay. So he denies it up until Penny Phelps comes in the room, gives him, what did you call it, a roadmap of what to say? Answer, I forget, something along those lines. Answer, okay. And you have already said she was telling April Walker what to say. Did you find it troubling that she was telling Rory Wilson what to say? Answer, I felt her method was much different than I would use being direct like that. Question, were you concerned that she was feeding Rory Wilson a story? Answer, yes. I did not care for the interview. Question, okay. And you were concerned that Rory Wilson was merely parroting back what she told him to say? Answer, I wasn't worried that he was parroting back. I thought that could lead down a road that would cause. It raised some concern for you? Yes. Is Danielle Malone in the control room, by the way, when this video is going on? Answer, I think she is there. Question, she's on the right, and we're looking up at the screen. There's just a still of the interview with Rory Wilson because she's in the room. Answer, correct. Who is in the control room? Answer, I don't remember for sure. Hernandez, I don't remember. Question, can someone in the control room stop the video? Answer, I believe so. Question, did you ever see Danielle Malone get up and stop the video? Answer, not that I recall. Question, so the story that Rory comes back with is that Tucker planned the robbery with people named Tony, Steve, and Tom, right? Answer, correct. Did you ever find Tony, Steve, or Tom? Answer, no. Question, do you believe that Tony, Steve, and Tom exist? Answer, no, I do not. Question, did you read Franklin Tucker his rights and have him sign a Miranda warning prior to his second interview? Answer, I'm sorry. Question, prior to his second interview, because you had him detained, where you guys claimed that he was free to leave, right? Answer, right. Question, and then you brought him in again, right? Answer, yes. Question, did you read him his Miranda rights? Answer, not that I recall. I believe it was read outside, but I do not recall. Question, do you have him sign a waiver to search his belongings at the upstairs apartment at the warehouse? Answer, no, not that I recall. Question, has Franklin Tucker ever done anything other than categorically deny any involvement in this? Answer, no, he is not. Question, and you're aware that he was incarcerated for over 700 days? Answer, yes. Question, and you're aware that he made lots and lots of phone calls, right? Answer, yes. Question, did you ever hear anything on those phone calls where he says he was involved? A, or answer, no. Question, categorically denied it, right? Answer, yes. Question, but yet you believe that he talked to Naheem Jackson? Answer, yes. Question, you confronted him with the bloody sneaker, right? Answer, that is correct. Question, and he told you they weren't his and they probably belonged to David Gross to White Detroit, right? Answer, yes. Question, by the way, Travis had David Gross's phone number, right? Answer, yes. Question, Travis was in possession with David Gross's phone, right? Did you get the phone records? Answer, I did not. Question, so David Gross is white, right? Answer, yes. Question, and Ty tells you they are probably David Gross's sneakers? Answer, yes. Question, and you sent them to the lab? Answer, yes. Question, did Ty come back as a match on a sneaker? Answer, no, he did not. Question, so that was true what he told you. They weren't his, correct? Answer, correct. Question, and you confronted him at that interview and confronted him with a mask and a knife, possibly having his DNA and later latent fingerprints. Is that what you said, right? Answer, yes, that is correct. Question, what did he tell you? Answer, it won't be his. Question, I don't care because I didn't have anything to do with it. Run whatever test you want, right? Answer, correct. Question, was his DNA on the mask? Answer, no, it was not. Question, was his DNA on the knife? Answer, no. Question, any fingerprints? No. Question, so what he told you was true? Answer, yes. Mr. Tucker denied April's story about him changing in the storeroom, right? Answer, correct. Question, is there, strike that. You believe Penny Phelps concocted that, right? Answer, no, I believe it happened. Question, you do believe it happened? Answer, yes. Question, didn't you just tell us that you believe Penny Phelps told April Walker what to say? Answer, I believe she helped her say the right thing and not lie. Don't over embellish or anything like that. Question, so you believe that April Walker saw Ty Tucker changing his clothes in the warehouse? Answer, yes. Question, but yet there's no evidence whatsoever to suggest that it actually happened, right? Answer, correct. Question, there's no forensics? Answer, correct. There was no investigation? Answer, correct. Question, there was no one else who saw this? Correct. Question, April Walker hates Ty Tucker? Answer, correct. Question, Penny Phelps was telling her what to say the second she met her, correct? Answer, yes, she was coaching her. Question, okay, Mr. Tucker told you he had been drinking heavily that day. Answer, yes. Question, was anyone concerned that Tucker was asleep in the warehouse when he was questioned? Answer, yes, I believe so. Question, and Ty told you that, right? I was sleeping. Answer, yes. Question, does there appear to be a pattern of truth to what Mr. Tucker told you? Answer, no. Big Scott, when I interviewed him later on, he also said that he didn't know what happened or anything like that, but that he thought Travis, Rory, and Tucker had been up to something. Question, okay, but he did tell you that he remembered drinking Fireball with Ty Tucker that night. Answer, yes. Question, and remembering him sleeping in the warehouse, right? Answer, yes. Question, and he thought that Travis had woke him up that night, right? Yes. Question, and he also told you, I know him. He's not a murderer, right? Answer, yes. Yes, he did. Question, how does he does not implicate Tucker? Answer, correct. Question, he told you to talk to him, right? Answer, yes. Question, when Penny Phelps started interviewing Travis, and I'll let Travis' attorney go into this, but did he show signs of the physical distress? Answer, yes. Question, did he tell you he was having a mental episode? Answer, I believe so, yes. Question, he has PTSD, right? Answer, yes. Question, is it proper to continue with an interrogation with a subject who's having a mental episode? Is that normal police procedure? Ms. Poist, I'm going to object. What do you mean by mental episode? Question, well, if he is telling you that he has PTSD, that he's suffering from an episode right now, is it proper police procedure to continue to interrogate? Answer, we have people with different things that will say they are having stress, and if they don't need medical attention and they're willing to continue, then they will continue. Question, did you ever get the phone records for Travis's phone? Answer, I believe we got them. I did not get to see them. Question, you did not get to see them? Were they turned over as evidence? Answer, I do not recall. Danielle Malone. Question, Danielle Malone. Did you like working with Danielle Malone? Ms. Poist, objection, relevance. Answer, there were some things that were tough. By Miss Higgins. Question, what? Answer, personality conflicts. Question, why? In terms of the way things are done. Question, would you characterize her as a good detective? Objection, relevance. Answer, no. Question, she is in dispatch now, right? Answer, yes. Question, I get the feeling that you are holding back about Danielle. Did you find her to be competent during the course of this investigation? Answer, I found out that a lot of things that I thought had been taken care of, I found out later they had not. Question, so she didn't tell you the truth? Answer, correct. Question, same thing with Penny Phelps, right? She didn't tell you the truth either, did she? Answer, no, at times, no. Not at times, no. Question, not at times. She went off and did her own thing and then came back to you and told you that things were done in a certain way, right? Answer, yes. But you believe she manufactured some of this evidence, right? She's not an officer anymore. She's not your captain anymore. Danielle Malone is not a law enforcement officer anymore. Penny Phelps is not a law enforcement officer anymore. You are. You have to tell us the truth. Answer, absolutely. Do you believe that Penny Phelps manufactured evidence in this case? Answer, yes, I believe she led some of the witnesses down a road. Question, she interviewed Travis. Did Travis come up with this story or did she lead him to it? Answer, there are parts of Travis's story that he said very early on that were him. Again, I believe the questioning was relatively direct, that she could lead him down. There are sorry, and we're going to continue this. I apologize. She said it again, exact same thing. She said, let me tell you what happened, right? Answer, yes, she did. Question, and after that, Travis's story changes, right? Answer, That is correct. Question. And again, we don't have the notebook, right? Answer. Right. Question. Was his vehicle searched? Answer. Yes, I believe so. Question. Anything found in the vehicle that supports Penny Phelps' theory of this case? Answer. No. Question. No. Now you were found to have. The finding was sustained by internal affairs of mishandling 178 pieces of evidence, right? Answer. That is right. Danielle Malone was also found guilty of mishandling 40 pieces of evidence, right? Answer. I don't know about hers. Question. You don't know about it? Answer. No, I'm not allowed to. No. Question. They don't tell other people? Okay. Did you hear about that? Answer. Actually, I knew something was sustained. I did not know what. Question. Do you know whether or not the charges against Penny Phelps were sustained? No, I don't. Question. Were you aware that the allegations were that she mishandled 208 pieces of evidence? Answer. I was not aware of that. Question. She was terminated because of this case, right? Answer. Yes. Question. She mishandled evidence, at least 178 pieces that you are aware of. That included physical evidence, DNA evidence, audio recordings from the case, right? Answer. That is right. Question. Did you admit to internal affairs that most of the physical evidence that was mishandled was kept in your office? Answer. Yes. Question. Do members of the IT office or janitorial staff have access to your office? Answer. Not that I'm aware of. Question. Nobody comes in and vacuums? Answer. No. Question. Takes out the trash? Answer. I take out the trash. The trash, either they come when I'm at the office or I have to put my trash outside my office. Question. Did you ever leave the office to your door open when you weren't present? Answer. No. Even when you go to the restroom? No. Question. So the state attorney's office was aware of all these problems that you had, right? Answer. Yes. Colleen Dunn was aware of it, right? Yes. What did she tell you to do? Because I know she told you to do something. That I don't recall. Question. You don't recall? No. Did she ask you questions about how this happened? I think there were two different parts. She would ask what happened with the body cam. Question. What happened to your body cam? Answer. Yes. Question. What happened to that recording device, right? Answer. Yes. What happened to your phone? Yes. All right. So you haven't got the flavor here of what Mr. Tucker was talking about and why he wanted to get the IA report in and why he feels bootstrapped right now when he doesn't have access to Pitcher to come on and talk about the 208 pieces of evidence are mishandled by Captain Phelps, who pretty much comes in and takes over his investigation. 178 pieces of evidence are mishandled by this detective. 40 pieces of evidence are mishandled by Detective Malone when she's handling the case. That's why this thing has been stripped down to nothing but John Travis Johnson. And John Travis Johnson has withstood time, at least to the point that they're going to put him in front of this jury as the only piece of evidence they have, because everything else fell apart. Everything else was mishandled. Everything else was not credible. This is an incredible story, ladies and gentlemen out here, if you're watching this. This is why Franklin Tucker is mad. This is why this is what you're seeing in that courtroom. So the next thing we're gonna jump ahead here to 223. I'm just gonna start taking the pages at a time because we've still got quite a few pages to go, and I want to get through. I want to get through some of these things because some of it's important. So this page here, Phelps continues to assert it was Tucker in the Keys electric video when clearly he was not in the video. So let's talk. Let's find this area. So let's go back. Actually, we're going to go back to 221, I think. Yes, and pick up on this question. All right. So she says, fighting this case, not sure we will get to talk to him. Claims he was asleep when all this happened. She's talking about Franklin Tucker in this. One thing we need to check, if that's Franklin in the video walking to Tom Thumb, would that have been after the incident? And if so, would those be same clothes April says she sees him take off? Now, this is after it's already been established. She's saying this to him after it's already been established and known that Travis is the guy in that video. Anyways, defense attorney is focusing on the Tom Thumb video and a timeline. Why would he be walking around in bloody clothes? Right? Answer, right? Question. So she's under the impression that the Tom Thumb video, I'm assuming she means the Keys Electric video. Answer, yes. Question. She's under the impression that it's Ty. Who told her that? Answer. That I don't know because I said it right. After that, it was not him. Question. I will double check the video, but when I viewed the video before, I was confident it was not him. Right? Answer. Yes. Question. But Penny Phelps kept saying it was. Answer. Correct. Question. She said, I thought so too. Right? Answer. Yes. Question. And then she starts talking about the bond, 500,000. You're okay with that, right? Yes. Question. Okay. And you say, my only concern would be when he finds out about Jackson, he may try and run at that point. I don't know, right? Answer, right. Question. And you said that your guess is his crazy phone friend will be able to pay for it? Answer, correct. Question. Pay the bond? Answer, yes. Question. You think his phone friend was crazy? Answer. Some of their conversations, I listened to them in jail calls, seemed a little disturbing. Question. All those conversations that you listened to, he never said he did it though, right? Answer. No. Question. Adamantly denied that he had any involvement in this. Answer. Correct. Question. So at the end of August, allegedly, he starts talking to Naheem Jackson. Barrios talked to him on June 22nd, right? Answer. Right. Question. And you may have talked to him earlier than that, right? Is that what you testified to earlier? Answer. No, I'm sorry. Who? Question. Naheem Jackson. Now, Naheem Jackson is a confidential informant they tried to plant in a cell, and then they held out to the court that this is just a concerned citizen in the jail, no relationship with the police officers, no relationship with the DA's office, and he just happens to be housed with Mr. Tucker, and he hears Mr. Tucker make a confession. Turns out all of that's bogus, that he was a paid confidential informant with a long history of being a snitch. And Colleen Dunn held to the court knowing, this is why she got disbarred, knowing, or suspended, I guess I should say, knowing that he was a paid confidential informant, knowing he had a relationship with Detective Pitcher, knowing that he was not some concerned, unrelated citizen to this case. And she held to the court that at an Arthur hearing that, again, that this was true blue testimony. And it was only when this was discovered to not be the case that he was, in fact, a paid confidential informant by the state attorney's office and police department that the judge got so incensed that he set bond. So again, it knows no bounds what these people were doing, and even Mr. Pitcher, as much as he's willing to talk about these things, it's just disturbing at the lengths that they were willing to go. Now, the next section is Phelps talks about disliking Tucker on 235. So let's see here. Question. Was there video from Florida Keys Electric that showed the truck? Answer. Not that I know of, or not that I recall. Question. Was there any video of other people walking or video of any other people walking to and from the warehouse or Tom Thumb? Answer. Not that I recall. Question. And again, I may have asked you this, but who decided that just that 9-minute clip was a log that should be retained for evidentiary value in this case? Answer. Captain Phelps or Danielle Malone? Question. Okay. Were you aware of any reason that Phelps wanted to implicate Ty Tucker? Answer. No. Did she ever make a statement about disliking him? Answer. She did talk about disliking him. Yes. Question. Why? Answer. That I don't know. Question. Had she met him before? Answer. No. Question. Did she dislike him because he maintained his innocence? Question. Answer. I don't think so. I don't know. Question. She just didn't like him? Answer. Yes. And do you think that's why she implicated him? Answer. I can't say whether the dislike came before or after some of the statements and interviews. Question. Do you have any information about Tato Quinn being involved in controlled narcotics buys that night? Answer. No. Question. The video of Fernandez talking to Anathea Clay the night of the incident. Are you aware that it's only a portion that was put into evidence? Answer. Yes. Question. Did you ever question where the rest of the interview was? Answer. I don't recall exactly. I was told it was not there. Question. Did they say what happened to it? Answer. No. So this is Anathea Clay. I said there's only a minute and like 30 seconds of this interview. The rest of it's gone. So what are they hiding? Again, among other things. And again, implication here, Todd O'Quinn making a controlled narcotics buy from Paula. Was it Anthea Clay? It was known was a potential CI or was a CI. And are they protecting her? We don't know. What we know is that when this goes down, the police captain's on the scene, state attorney's office is on the scene, and they're all on the scene prior to the lead detective getting there, which is unheard of. All right, so let's go here. Phelps and Dunn had a long conversation before arresting Tucker, contrary to lead detective Pitcher's decision. Let's see here. Let's get back to okay. So actually, we're just going to keep reading all this. Question, who would have controlled the video? IT. Question, IT. Answer, yes. Question, did you ever ask Fernandez if he turned off his body cam? Answer, I don't recall. Question, and again, Fernandez was the one that picked her up, right? Answer, yes, I believe so. Question, and brought her back? Answer, yes. Question, did you ever have discussions with the state attorney's office about the strength of the state's case? Answer, yes. Question, and what was that conversation? Who did you have it with? Answer, Colleen. Question, what did she say? Answer, we had several conversations about it both prior and post arrest. Question, and what was the substance of those conversations? Answer, when she and I talked prior to Tucker's arrest, we talked about whether we had enough to arrest and whether we should go ahead and arrest or wait and see if we can get more. At that time, I did lean towards waiting. I know she and Captain Phelps did have a conversation, and the decision was made to go ahead and arrest. Question, you told Internal Affairs that Phelps and Dunn had a lengthy conversation, and that was the only reason why you arrested Ty Tucker. Yes. Question, because if it was your decision at that point, you wouldn't have arrested him. That is correct. And so after that happens, you have a continuing conversation with Colleen Dunn about the strength of this case. We talked a couple other times about things that needed to be cleared up, and that, obviously regarding the DNA, it's not favorable to the case. Question, okay. And it's because of the strength or the weaknesses of the state's case, that is why she wanted Jackson to talk, right? Objection calls for speculation. Answer, yeah, I can't answer what she wanted. I know that it obviously helps the case if he talks. Have you known Colleen Dunn to do that in other cases? The only other case that I worked with, I worked two other cases that I could think of with Colleen, and nothing like that happened with either of those cases. Just those two cases? Yes. I'm trying to decide if I ever worked any sexual battery cases, but there were two others that I recall, just two other homicides. Questions. Question, did any other detectives say that is what she does? Answer, I have never had that type of conversation with another detective. Question, would it have concerned you to know that in other cases, she also relied heavily on jailhouse snitches? Answer, possibly. Question, do you know that Colleen Dunn and Penny Phillips had conversations without you involved? Answer, I imagine so. Question, they had numerous conversations, right? Answer, question, they were close friends. They were close too, right? Answer, absolutely. Question, friends socially outside work? Answer, share details of their personal lives, right? Yes. Question, talked about their hatred for me, right? Answer, yes. Question, okay, did you ever get the feeling that decisions were being made without you or your involvement? Answer, yes. Were you told to do things that you were sort of unaware of how you got there? Answer, yes. Question, okay, like what? Answer, concerning the conversation of going about getting April and Anthea, and then how the interviews went, and then also the search warrant for the warehouse, and some of the conversations we talked about. Question, so Penny Phelps and Colleen Dunn are talking the whole time in the early stages of the investigation? Answer, yes. Question, Colleen Dunn is intimately involved in Penny Phelps talking to April Walker, yes? Answer, yes. Penny Phelps talks to Rory and talks to Travis, right? Yes. Question, okay, so Penny Phelps is talking about everything she's doing in this case with Colleen Dunn. I believe so, yes. Question, you heard them on the phone, right? Yes. Question, and you heard Colleen was involved in all of it, right? Yes. Question, did you have any understanding that Colleen was directing Penny? Answer, yes, I believe at times. Question, telling Penny, wouldn't it be nice if someone said this, that kind of stuff. Answer, that we need to get in, or we need to go talk to this person. We need to find this. We need to find out what happened. Or we need to make it up. Answer, not as far as I know. Question, did you ever bring this to anyone's attention? Answer, no. So Colleen Dunn, before the prosecutor got this case, she was doing all this while this was in the investigative stage, right? Answer, yes, that's correct. Question, so she's at the crime scene, yes? Answer, yes. She's talking with Penny Phelps, yes? Yes. Several times a day. Answer, I would be speculating. I assume so. I know they talked a lot. Question, at least every day. Answer, yes. And she's telling Penny Phelps what she should do, right? What she should do. Answer, yes. She would put out things that she wanted done. Question, things that she wanted done. Answer, yes. Question, and she made the decision along with Captain Phelps, former Captain Phelps, against your advice to arrest Franklin Tucker. Answer, that is correct. And you had the conversation with Colleen Dunn. You said, wait, right? Answer, yes. Question, but then Penny Phelps and Colleen Dunn have a conversation and you are ordered to go and arrest Franklin Tucker. Answer, correct. I shouldn't say I was ordered. It was Malone that was told to write an arrest report. Question, Malone was told to write an arrest report. Answer, correct. Question, did you ever review that arrest affidavit? Answer, I did when it first happened. Question, are there inaccuracies in that arrest affidavit? Answer, from what I recall, there were a couple, yes. Question, so Phelps tells Malone to write an arrest affidavit. Is that normal since you're the lead detective? You should have wrote it. Answer, correct. Question, but then you did think there would be enough, right? Answer, right. They also had her write the arrest affidavit for Rory Wilson as well. The only one I wrote was Travis Johnson. Question, okay. But they knew at the time when they directed Malone to write the arrest affidavit, they knew you weren't on board. Answer, correct. Yes, they knew I thought we should wait to arrest him. Question, right. So they got somebody who would write it, right? Answer, I am speculating, but yes. That is who she directed to do it, but I just know that she didn't come to me and tell me. I'm having her write it since you think we should wait. Question, but she knew you didn't agree, right? She knew you didn't agree, right? Question, so instead of going to the lead detective in the case, they go to the now dispatched Daniel Malone. Answer, correct. To write it. Answer, yes. Question, because they are all friends, right? Answer, yes. Question, they are all close personal friends outside of work. Answer, yes. Question, and I am saying them all, Colleen, Penny, and Danielle. Answer, except Danielle and Colleen. I think they were friends now, but I can't say at the time they were. Question, okay. Answer, but Penny and Colleen, and obviously Penny and Danielle were also. Question, do you feel like the case got away from you early on in the investigation? Answer, yes. So I had actually asked not to be the case agent twice. Question, twice? I asked Detective Kallenberger the night of, because I had training that I was leaving for in 2 weeks and I was going to be gone for a week. And my house had been destroyed by the hurricane. We were kind of homeless at the moment. He said, we work as a group. We work as a team. They're called the case agent, even though we do everything as a team, and he was gone. And then the following week, I asked Captain Phelps again, first time for her to not be the case agent. Some exact reasons, and she told me basically the exact same thing that Detective Kallenberger told me. It's going to be a team effort. You're the case agent, just a title, but we're going to work together. Question, and Colleen Dunn was on that team? Answer, yes. Question, do you feel like you lost control over this investigation when Colleen Dunn and Penny Phelps, Danielle Malone? Yes. The case was run by Captain Phelps and Colleen Dunn. Question, Captain Phelps and Colleen Dunn? Answer, yes. Question, and you didn't feel that you were in a position as a detective to tell them you're wrong, right? Answer, correct. Question, or to tell them I don't like what you just did, right? Answer, correct. I could give my opinion, but I didn't have a say as to whether we do something or not. Question, did you feel like you were in a position to argue with them? Answer, no. Question, why? Answer, commanding officer, I do not think I should do that. Question, how about Colleen Dunn? What is she? Answer, she is a prosecutor. Question, and now a suspended attorney? Answer, correct. Question, for lying and hiding evidence, right? Answer. Actually, I don't know what she was suspended for. I know she was suspended. I just don't know the specifics. Question. Is there anything else you want to tell us about the investigation about Penny Phelps, Colleen Dunn? Answer. No, I can't think of anything. All right. So we're going to go now to part 2. I've got to go in here, I believe, 297. Give me a moment. Actually, I guess the numbering's off on this. We're going to have to flip through. I apologize. We only have 2 more excerpts to go through, and both of them are on 297. So this is the final page. And the pertinent information here is when Captain Phelps gave an order, you better follow it or else. And if you didn't follow Captain Phelps' orders, there were consequences. So let's read this here. Oh, question. Okay. I mean, I understand that you got stuck with Penny Phelps for however many years you were stuck with her. But the order of ranking the captain gives an order, you follow it, correct? Answer. That is correct. Question. And is it fair to say that when Captain Phelps gave an order, you better follow it or else? Answer. That is correct. Yes. Question. And if you didn't follow an order from Captain Phelps, was there some type of punishment or retaliation by Captain Phelps for not following her orders or challenging her or questioning her? Answer, yes. I mean, I think she was pretty clear. If you didn't follow, she was in command. And if you didn't follow her orders, that there were consequences. Question. And consequences like I'll fire you if you don't follow my orders? Answer. I don't think she has the ability to fire. She can move you from the unit and put you somewhere else. Question. Like ticketing or, like having you walk a beat or horseback or something you don't want to do. All right. So that concludes section 20. That concludes the excerpts from the pitcher deposition. But what you should have taken from that, I mean, is the absolute corruption that was surrounding these prosecutors and the way they acted, the way they went after Tyrone Tucker with zero evidence, and they manufactured evidence. And Penny Phelps implanted stories in April Walker's mind, in Rory Wilson's mind, in Travis Johnson's mind, and for whatever reason, she just didn't like Tyrone Tucker. And on top of that, I don't think she was going to let her colleague, Malone, Danielle Malone, go down for the Facebook mistake. So as a result, they decide we're going after Tyrone Tucker. Now, what we're going to do, we're going to get back into the motion now and finish reading this motion because there's a lot more context, there's a lot more information. But this was the bread and the butter here of, and you should now have a much better understanding of why Tyrone Tucker feels the way he does, acts the way he does, and is comporting himself the way he is in court. Because, I mean, wouldn't you? Anyways, let's get this report back up here. Give me one moment. All right, so we're back here. So now we're going to move on now. Again, you have a flavor now. You've seen the deposition, you've seen the testimony. Now some of the testimony that we just read together, this will put it in context as to what it means, what it ties into, and why they were asking these questions. So let's continue on here. 21. Pitcher admitted under oath that he knew Phelps, his boss, disliked Tucker, and that she led witnesses, coached witnesses, manufactured and mischaracterized evidence to implicate Tucker. Pitcher admitted under oath that he knew Dunn and Phelps were friends, that Dunn and Phelps completely took control of this case, and that there are consequences when Phelps' orders are not followed. 22. Dunn's presentation to the grand jury, as the defense has suspected, is another clear act of prosecutorial misconduct by Dunn and requires the dismissal of both the information and the indictments of this case. Now, we don't have access to the grand jury transcripts in this file here. I believe they were sealed. but they reference them here. 23. The examples of Dunn and Pitcher concealing exculpatory evidence regarding Tucker are multiple. What's worse, the state, through Dunn, omit material facts, make intentional false statements, and make statements with reckless disregard for the truth. This is the definition of perjury by any standard. 24. The state has an obligation to dismiss both the indictment and the information. If the state continues to violate defendants' due process rights, the court must intervene. The law is clear. If an affidavit for a search warrant contains intentional false statements or statements made with reckless disregard for the truth, the trial court must excise the false material and consider whether the affidavit's remaining content is sufficient to establish probable cause. This rule contains two components. First, the trial court must determine whether the affidavit contains an intentional false statement or statement made in reckless disregard for the truth. Second, if the court finds the state acted deceptively, the court must excise the erroneous material and determine whether the remaining allegations in the affidavit support probable cause. If the false statements are necessary to establish probable cause, the search warrant must be voided and the evidence seized as a result of the search excluded. 25. Omissions made with intent to deceive or with reckless disregard must also be considered. The only difference between omitted facts and misstated facts is that in the case of omitted facts, the reviewing court must first determine whether the omitted facts, if added to the affidavit, would have defeated probable cause. The reviewing court must further find that the omission resulted from intentional, reckless police conduct that amounts to deception, and it absolutely did here. When a material fact is omitted from the affidavit filed in support of the probable cause determination, such fact constitutes a material omission if a substantial possibility exists that the omission would have altered a reasonable magistrate's probable cause determination. Here are several important and relevant facts that were intentionally omitted, which, when considered together, not only show a clear lack of probable cause, but also demonstrate the extent of Colleen Dunn's willingness to present perjured testimony to the grand jury. Here we go. Todd O'Quinn, 27. On page 31 of the grand jury transcript, Detective Pitcher testifies that alleged victim, Todd O'Quinn, reported that he saw the second suspect run from the treehouse, lift his mask, and could tell he is white. What Detective Pitcher and former attorney Dunn omitted was that Todd O'Quinn described this second suspect as having curly brown hair and differing in weight and height to that of defendant Tucker. Further, they also omitted that Todd O'Quinn specifically told them that he knew Tucker and it was not Tucker. They also omitted that when showed a photo lineup, O'Quinn told them the second suspect looked most like co-defendant, now turned state's witness, John Travis Johnson. Again, logic dictates that there's no conceivable way Pitcher would omit the statements by O'Quinn unless he was directed by the prosecutor to state only part of what he said and not the exculpatory aspects of his testimony. Clearly, this is evidence of a conspiracy to obstruct justice and to present perjured testimony to the grand jury by submitting selective testimony that perverts the true meaning and significance of O'Quinn's statements. He had the grand jury heard that O'Quinn saw the suspect, knew it was not Tucker, and had in fact told the police the suspect he saw he identified as Travis, the grand jury would not have had probable cause to indict Tucker. 28. Had Pitcher testified truthfully before the grand jury and told them what he told the parties at his deposition, no indictment would have ever been returned in this case. Dunn knew Pitcher did not believe there was probable cause to even arrest, much less indict Tucker. Dunn concealed that from the grand jury. Dunn was personally and extensively involved in the investigation of this case. Dunn concealed that from the grand jury. Pitcher never told the grand jury that Phelps said, "I hope Todd can ID him," meaning Tucker. Otherwise, Jesus Christ, we're all in trouble. And that Todd not only never identified Tucker, but that it was not Tucker. Dunn never disclosed this recorded statement she had in her possession and control to the grand jury. 29. All of this culminated in Dunn's careful and intentional presentation of selective statements elicited by a prosecutor who knew they weren't true to mislead the jurors in furtherance of her conspiracy to obstruct justice. Confidential informant 30. On page 39 of the transcript, Pitcher testifies that a confidential informant approaches two officers days after the murder. This man was not a confidential informant, and Pitcher had no idea whether he was a confidential informant at the time. He recklessly disregarded the actual truth to bolster the credibility of the witness. Paula Bellamont, 31. After telling the grand jury that the information obtained from this confidential informant led him to defendant Tucker, who told them that Rory Wilson lived in the warehouse with him, Pitcher talks about meeting with victim Paula Bellamont. Pitcher tells the grand jury that Paula identifies Wilson immediately. After being prompted by Dunn, Pitcher tells the grand jury that Paula said she was 100% certain Wilson was the person who committed the murder robbery that night. What Pitcher and Dunn omitted was that Paula had told them Tucker was not involved in this incident. During the sworn deposition testimony of Paula Bellamont, she stated numerous times that she was positive that Franklin Tyrone Tucker was not involved in the robbery homicide and that he was not the second robber who the state alleges was in fact Franklin Tyrone Tucker and the killer of Matthew Bonnet. Paula Belmont stated that she personally knew Franklin Tucker and spent over an hour with him the day after the incident. She stated the second robber the state claims was Franklin Tucker had a different body style, size, and voice. She stated that she is positive it was not Franklin Tucker, and she so told Detective Pitcher and the state attorney's office this on many occasions. Had the grand jury been presented with the truth at this juncture, they would have known that Pitcher did not believe there was enough evidence to arrest Tucker. So Phelps and Dunn had a conversation, and Phelps ordered another officer, not lead Detective Pitcher, to write the arrest affidavit. They would have known that not only O'Quinn, but also Belmont both said the second suspect was not Tucker. They would have known that O'Quinn actually identified the second suspect fleeing the scene as Travis Johnson, not Tucker. I hope you are seeing why the state didn't want O'Quinn on the stand. If you haven't already seen it in my videos, that's why they don't want him. When considered together, the state intentionally misled the grand jury as to defendant Tucker's involvement, causing the grand jury to indict Tucker on knowingly perjured testimony, requiring the dismissal of the indictment as required by the Florida Constitution in Anderson v. State. 34. Had they not conspired to present perjured testimony, the grand jury would not have had any probable cause whatsoever to link Tucker to any of this. Rory Wilson, 35. Rory Hank Wilson, hereinafter Wilson, recently took the stand in his own defense at trial. When questioned about his post-arrest statement, in which he said, in substance, that he entered the treehouse with Tucker to commit a robbery, he told the court and the state that he had been coerced by Phelps to make that statement. He testified that Phelps had threatened his pregnant girlfriend. He testified that Tucker was not even with him that night. 36. Dunn and Pitcher knew the truth about Rory Wilson's statement. Pitcher told the state he watched Phelps tell Rory what to say, led him down a path, insisting Rory implicate Tucker. They knew at 1:18 a.m. the morning of Rory's statement, Rory says, if I say Ty did it, can I go home? And then suddenly the recording stops, and 3 minutes of the recording are missing. They didn't tell the grand jury that once the 3 minutes recording suddenly continues, and Rory tells Phelps a story of how Tucker helped to plan the robbery. Pitcher never told the grand jury that was concerned that Phelps fed Rory the story he should tell. 37. The state is aware that Dunn and Phelps later obtained statement after statement from Wilson in a blatant act of manufacturing evidence. The state knows that when Dunn received the lab results from FDLE exonerating Tucker, they went back to Wilson and had him create a ridiculous story about knife throwing at the warehouse to create a theory about how Wilson's prints wound up on the knife. They went so far in their vendetta against Tucker that they protected the people they knew were involved in this robbery murder, Wilson and Johnson. Despite Anathea Clay being identified as a suspect over and over again in the investigation, Dunn and Phelps insulated her from the investigation. Question is why? Again, maybe that answer would also answer the question of why they were on the scene to begin with before the lead investigator. Dunn and Pitcher lied to the court about her whereabouts. They did everything they could to protect the real suspects, Wilson, Johnson, and Clay, in their malicious prosecution of Tucker. At the grand jury, Pitcher and Dunn knew Phelps told Wilson what to say. They supplied the grand jury with manufactured evidence. The testimony to such knowing falsehoods is tantamount to perjured testimony, and no defendant should be forced to defend himself at a trial based on such testimony. April Walker, 38. Dunn and Pitcher talked about April Walker with the grand jury. Dunn leads Pitcher on page 50 of the transcript, asking if the clothes they found in the bag they saw Rory Wilson with days after the robbery were something that Rory Wilson could fit in. Pitcher testified that they would have been very small on Rory Wilson after he tells the grand jury that defendant Tucker is quite a bit smaller than Mr. Wilson and that he's pretty skinny. The state had absolutely no evidence whatsoever to even suggest that defendant Tucker's clothing was in the bag they saw Wilson with. 39. At his sworn deposition, Pitcher testified that he believed April Walker was being told what to say by Phelps. He said he found this very concerning. Pitcher and Dunn knew that Dunn personally made decisions about April Walker without him and with Phelps. Dunn knew April Walker's statements were completely manufactured by Phelps, yet she presented this perjured testimony to the grand jury. During the investigation of this case, blood, DNA, and trace evidence was recovered from the scene, as well as from a knife and a mask recovered nearby. The FDLE laboratory analysis revealed that the blood and DNA evidence all implicated Wilson. His DNA is on the inside of the mask and the knife, while the blood of the victims, Bonnet and Paula Belamonte, is on the knife and mask. 41. No blood, DNA, trace evidence, or fingerprints of any kind are linked to Tucker in any way whatsoever. The state knows this and knows Pitcher gave this grand jury patently false information he knew was untrue to mislead the grand jury into believing there was physical evidence linking Tucker to the crime. Travis Johnson, 42. On page 55 of the transcript, Pitcher lies to the grand jury about Travis Johnson. Pitcher tells the grand jury that at the time of the defendant Tucker's arrest, he had no idea who Travis was and that he had no knowledge that he had any involvement in the crime. This was absolutely false. Phelps interviewed Travis Johnson the night of the murder. Dunn was on scene the night of the murder. In fact, the former prosecutor arrived on the scene before the lead detective. Another fact the grand jury did not hear. That night, Phelps interviewed Johnson at the warehouse where he also lived right after the murder, while he was packing up his truck. It is unfortunate that Phelps, a trained law enforcement officer, didn't find that a man matching the exact description of the second assailant, packing up his truck to flee in the dark late at night, a stone's throw from the crime scene, was suspicious. The grand jury was deceived again by Dunn, likely to cover the complete incompetence of her friend and co-conspirators. Dunn then leads Pitcher to testify on page 56 that Wilson and Tucker used Travis as their alibi that night, when that was also an untrue statement. While both Tucker and Wilson told police they were with Travis at various parts of the day. Tucker never used Travis as an alibi, and they knew it. Conclusion, 44. There can be no dispute that ASA Colleen Dunn and Detective Pitcher presented perjured material testimony to the grand jury. This conduct alone is a violation of the Florida Constitution, and the Florida Supreme Court requires that any indictment based on such conduct must be dismissed. 45. In addition, the state has since conceded that the only evidence in this case against the defendant is the bargained for statement of John Travis Johnson. The statement of Johnson is completely unreliable, and the state knows it. Dunn and Pitcher knew that before Johnson made his statement. Phelps spoke to him uninterrupted for over 6 minutes and told him exactly what to say. He even moved to suppress his statements prior to his trial on the grounds that Phelps coerced him. He had the state presented Johnson's statement to the grand jury, along with Pitcher's truthful testimony, and not some prepared script by Dunn, and not bolstered it with numerous perjured statements, they would have seen that there is no evidence in this case whatsoever that Tucker committed this crime. Therefore, it must be concluded that Dunn presented the same perjured testimony to the state attorney when establishing the basis for the information against the defendant. For this reason, the information, as well as the indictment in this case, must be dismissed. The egregious prosecutorial misconduct and intentional use of perjured testimony by the state in this matter mandates the dismissal of all charges in this case with prejudice. Wherefore, the defendant, Franklin Tyrone Tucker, respectfully requests that this court enter an order dismissing the indictment and information against him, and for such other and further relief as to this court just improper. So that's it, guys. That is the motion, a very important motion. And I really hope that having heard the testimony that backs this up, and again, I'm not going to, I have a copy of the FDLE report where you can put it up, but it was already entered into evidence in court showing that Mr. Tucker, no DNA. There's not a video that shows him on it. There's nothing connecting him to this case. He goes to pay his phone bill. He's seen by Detective Malone. She starts looking at his Facebook. She brings that to Penny Phelps. For whatever reason, Penny Phelps was involved in this case to deflect attention away from someone. We assume it's Anathea Clay for a reason. We don't know why. We just know that she's involved in a case, and it's not custom for her to be involved in this case. It's not customary for a captain to be involved in the case. And then we know that once she gets her eyes honed in on Ty Tucker, she goes full at him. Not to investigate, not because there's evidence. She says, we got to figure out how to find evidence to support this theory. Why do they need to do that? We don't know. We can't answer that. But what we can say is that this investigation, 208 pieces of evidence mishandled by this detective or captain, 40 pieces mishandled evidence by Malone, 178 pieces of evidence mishandled by the lead detective in this case, Mr. Pitcher. Evidence not stored properly. Tapes destroyed. Evidence destroyed. A black sedan, if there was a black sedan, never run down, never investigated, never looked into. Numerous people were known to be in that treehouse area, home, whatever. Some were not even contacted, questioned. One individual who Daniel Malone goes to speak with, who would verify that April Walker was never threatened by Tyrone Tucker. Body cam is missing. On top of that, you might be surprised to hear that this individual, that man, is sentenced and he's given probation with a condition that he has to leave Florida and never come back. And he's told, if you ever come back, you're going to jail. You think that's going to be somebody who's willing to come back to Florida to help Ty Tucker if he needed to in this trial? The prosecution has done everything they can to get rid of any evidence that proves Ty Tucker's innocence. Unfortunately, it leaves them only with Travis Johnson. The question is, are they going to get away with it? And my answer to that is no. And I don't believe they're going to for a multitude of reasons. Number one, we're going to keep bringing light to this, right? We're going to keep bringing light to this and bringing eyes to this and bringing attention to this. Secondly, Ty Tucker put on a heck of a case. He testified from the heart today in court. And I believe tomorrow, when he delivers his final closing argument, he's going to put the final nail in the coffin for this case. And he will be going home with a not guilty verdict. I'm 100% convinced of this. But ladies and gentlemen, we're going to conclude here. We've gone for almost 3 hours. 3 hours. If you've watched all this, I hope you have, because if you have, you should have come away with an understanding, a new understanding of this case. A new understanding of this case. But remember, justice dies in darkness. The system doesn't work well when it's dark. The system works better when we're watching, when light's shining down. And a case like this requires us to watch. And you've seen why. It's an incredible case. This is real. this actually happened. And we hope that those 12 individuals sitting in that box have seen this case for what it is and will come back with a not guilty verdict. With that said, guys, I'm going to jump off here. And I'll see you in the courtroom tomorrow to watch closing arguments and watch this thing conclude. And until then, guys, let justice prevail. And I will be talking to you soon.